Good luck. Take a look back. I'm lost. What is it called? Oh, no. But. They've gone. So let's just have to make. Well, let's get some.
All right. Well, circuit court now in session, the Honorable David L. Wigg presiding. Make sure all your cell phones are off. They have them on the side prayer. Thank you. May be seated.
We'll fill back.
Oh, they started the man. Well, you've got to, it's gonna act, well, I mean, it's gonna be an act. I can figure that.
Just that you won't have your own, you put when you talk with folks. Back there. What is that? She owes.
Okay, we have a little technical glitch about.
Yeah.
Commonwealth versus Tony Albertson.
Good morning, Mr. Albert.
We have the pre-trial conference.
We have a plea draw.
As opposed to plea of diversion or a felony.
It's felony.
This is 24 CR 0042, Commonwealth of Kentucky. This is Tony Albertson. Are you Tony Albertson?
Yes,
You were born in 1984.
Yes.
Last four digits of your social security number 9471. Is that correct?
Yes.
I understand you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
Oh,
Is this plea freely and voluntarily given? Is this plea freely and voluntarily given?
yeah,
Are you the same person named in indictment number 24 CR 0042?
yeah,
Is your judgment impaired today in any way?
no,
Have you discussed this matter with your attorney and are you satisfied with his advice?
yeah,
Have you reviewed the evidence the Commonwealth has against you? You feel like you're fully informed about your case? Are you fully informed about your case? You
Yeah.
reviewed the evidence with your attorney?
yeah,
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say you have a right to speak trial with jury. right to be represented by counsel all phases of the case, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses yourself, and have process issued to compel their attendance, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a plea today, you give up those charges, those rights. You understand that?
Yeah.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting any recommendation, I will wait the pre-sentence investigation report from probation parole. In the event that I do not accept the recommendation of the Commonwealth and decide to impose a harsher sentence, you will have the right to withdraw your plea and proceed to trial. You understand that? Y'all will step to your left, please. Mr. Stockton, will you come forward and tell us what the Commonwealth's offer is?
Yes, Your Honor. Mr. Albertson will plead guilty to escape second degree, receive a sentence of 1.5 years. He will also plead guilty to possession of controlled substance first degree, receive a sentence of 1.5 years. They shall run concurrently for a total of 1.5 years. Commonwealth will oppose probation. This sentence will run consecutively with Clinton Circuit Court Case 21 CR 4. And all evidence in this case will be destroyed.
Is that your understanding of the Commonwealth's
Yeah.
recommendation?
Yeah.
Are you pleading guilty because you didn't commit the acts charged in the indictment as amended?
Yeah.
Are you doing so of your own free will? You doing so of your own free will?
Yeah.
Okay, you know your constitutional rights. I explained to you earlier. Are you waiving them and allow the court to fix your punishment?
Yeah.
Okay, you understand that by entering this plea of guilty, any future convictions of felonies could be enhanced from the persistent felony offender law.
Yeah.
Okay, is that your signature there on the motion?
Yeah.
Okay, I'll accept the agreement order pre-sentence investigation report. Be done by probation, parole, and schedule sentencing for August the 8th.
Judge, we can waive this if you would like
Is he a
to.
state prisoner?
He is a state prisoner.
Well, I will go ahead and waive it and enter the judgment.
Your Honor, and since you're doing that, I would point out, Mr. Poindexter pointed out to me, there's an error in the paperwork. Under dismissed, the promoting contraband first degree should also be dismissed.
Okay, we'll just leave that in the judgment. Okay,
Thank you,
very much.
Thank you.
Daniel Morland. Daniel Morland, percent. Yeah, percent. Commonwealth versus Daniel Morland, 08 CR 0079 and 08 CR 78. Mr. Morland, yes, sir. Good morning. You represented by counsel here.
Yes, Judge.
We're here today for the purpose of sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Yes, sir. Is it substantially correct?
Judge, it was I'll note for the record, it was an update. Mr. Morland had served significant time. In the review, the time we had, I don't believe there are any errors, but again, noting that it was updated, I don't think they had a chance to properly.
We'll reschedule the sentencing then for August the 8th.
Well, Judge, when we were here last time, you had indicated that you wanted Mr. Morland present for arguments that were made. I made some arguments relating to the underlying case. I'm ready to move forward with those.
Well, that's good, but I don't want to proceed with this if you hadn't had an opportunity to look at the pre-sentence investigation.
Well, Judge, we just reviewed it.
Well, I mean, either you did or you didn't.
We reviewed.
I want to give you plenty of time to do it. I was defense counsel myself, and I know how you can expose yourself if you make a statement. Well, we looked at it pretty well, but maybe, so I want him to thoroughly go over it with you, and I want to give him time. It's not going to make that much difference where you sentence him today. He's already a state inmate, isn't he?
That's correct, Judge.
Is he
However,
a state inmate?
he is Judge. However, in light of the ruling and depending on what the court chooses to do, I don't know that may be the case. Mr. Morland has expressed his desire to withdraw his guilty plea. Judge, my understanding of the prior ruling or the ruling at the Supreme Court, the sentence was illegal. So it would be impossible for the court to sentence Mr. Morland to what was negotiated on.
A portion of the plea was illegal, and what you're saying, it makes a a difference in what he would have done.
Absolutely, Judge. And secondary, Judge, if I'm looking at the PSI, it notes all three charges. My problem with that is Mr. Morland served an entire 10-year sentence. So essentially, the sentences were 10 consecutive.
I don't want to get into this portion of it right now, but here's what I'm afraid of. What if he withdraws his plea and tries the case again? Does the time he served, will it count against what he served on the plea?
I don't have an answer to that. I can try to get one.
Surely don't want to do that if that's the case. You understand what I'm saying?
I do, Judge.
You understand what I'm saying, Mr. Moore? I mean, and I'm sure your attorney will look into that and advise you that.
And Judge, I think that it's a cart before the horse. So that's,
So here's the only part that I want.
I understand.
I'll listen to all your arguments at any time, but I want to know that he's thoroughly reviewed the pre-sentence investigation report. So if there's any changes in that which might affect my judgment after I hear your argument, that's all I'm saying. Okay? And if you want to give it to him, go back there and let him read it again. He comes out and tells me that he's satisfied with the amount of time that he's had to look at the pre-sentence investigation report, we'll proceed. Otherwise, we won't proceed. Okay?
We'll proceed that way, Judge.
Okay. Commonwealth versus James Armstrong. Christie Beatty.
Your Honor, we settled, this case was set for trial next week. And we got an agreement. We met, got it all worked out, got her paperwork up. I don't know if she understood she's supposed to be here today. We're trying to find her. I think she's been very diligent and I think there's been miscommunication, so we're trying to get her up.
She was at the negotiation day and we entered an agreement, so I would give her a little time to get here.
She, you know how people are, she may have thought she's supposed to see her on the 30th, whatever day that was.
Jacqueline Bell.
That's to be dismissed verdict.
Jordan Bridgeman. Says there's an active warrant out for Mr. Bridgeman.
It's been took care of. Yes, sir.
Has it been processed or?
Sure.
Are you Jordan Bridgeman?
Yes.
Were you born in 1997?
Yeah.
Last four digits social security number are 0614.
Yes.
The last, you're here on 24 CR 0056 for the purpose of arraignment. You're represented by counsel. You have a right to remain silent. If you have any questions, step away. The grand jury of Clinton County's returned an indictment charging you with theft by deception and failure to maintain theft by failure to make a required disposition. Mr. Cross, you acknowledge the identity of your client received indictments. Wait formal reading and arraignment interview not guilty, reserving all pretrial motions.
Correct, Your
Signing
Honor.
reciprocal discovery order. What is the negotiation date?
July the 31st at 1 p.m. in person.
July 31st, 1 p.m. in Burksville. You're to be in Burksville at the Justice Center, July 31st at 1 p.m. And the next day that you're supposed to be here is August the 8th, and both of those are conditions of your bond, okay?
You don't want to be acknowledged, then you can go. Okay.
Gail Brown. I'm Kentucky versus Gail Brown, 24 CR 0045. You are Gail Brown,
Yes, sir.
born in 1973. So the last four digits, social security number 6063.
Yes, sir.
This is 24 CR 0045. What do you got, sir?
I've spoken with counsel here. I think there's been,
You'll move over this way.
I spoke with counsel. There was a discovery conference that was held on July the 3rd where some discovery issues were brought to our attention. I think we have presented him with the discovery. Is there any other items that we need to get you at this point or?
think everything's in now to kind of negotiate.
Gotcha. Would the court consider setting this for another pretrial conference? I think maybe it's 8th date, it's the next available one, to see if we can reach a resolution on this one.
What is the charge?
Trafficking and possession and DUI.
What's the quantity?
About 24 or 25 peels, I believe. I got the police report here. I can tell you specifically. And the circumstances were, he was at a gas station. He was found in his vehicle. Officers started talking to him. They did a search of the vehicle. They found these pills loose in the vehicle. He also had a large quantity of cash. So,
Well, you just want to. You made all the discovery. You made them an offer yet?
No,
no, we have not, Your Honor.
Well, there's no reason, we usually have negotiation days. There's no reason, no reason for you to set your negotiation date on the same day as the other cases are, but, you think you'll be ready to set this for trial on, August the 8th?
trial resolution, Judge, sir.
Yeah, you mean set a trial for the 8th or
No,
by
on
the
the
8th? No,
eighth is our next rule day. I want y'all to be here with a plea or we'll set a trial
Gotcha.
date.
Yes, Your
On
Honor.
the 8th.
Yes,
Could
sir.
definitely be working.
Thank you, Your Honor.
Right. And Your Honor, that's all I have.
Yeah, have a great day.
Yeah, you too.
On Eric Clable, Mr. Clable, your attorney said it's gonna be 10:30 before he gets here, so we'll call you then, okay? He called over a few minutes ago. Yes, cases in another county. Want to make sure you got over here and had time to talk to you.
Can I speak?
Pardon?
I said, may I speak?
Well, what do you want to say?
He talked to me yesterday and told me he couldn't be my attorney.
Well, he hadn't told us that. So he said he was gonna be over here.
No.
Yeah, right. Yeah, so. He might have had an epiphany between the day. Yeah, so. A lot, Alicia Cory. Commonwealth versus Alicia Cory, 24 CR 0020, CR 0025, 24 CR 0026. You're Alicia Cory, correct?
Yes, sir.
Born in 1984.
Yes, sir.
Last four digits of your social security number are 2380.
Yes,
You're
sir.
on 24 CR 0025 and 24 CR 0026. You have a resolution in this case?
Yes, Your Honor, it's a pretrial diversion plea.
The motion has been tendered. It says you wish to enter a plea today. Is that correct?
Yes, sir.
Well, you don't have to if you're hesitant.
I
Really?
know, but I've
You
been
wish-
offered a fair deal, so
Okay, are you currently under the influence of drugs or alcohol?
no, sir.
Is this plea freely and voluntarily given?
Yes,
You previously were identified, you're the same person that's been indicted in, 24 CR 0025 and 26, is that correct?
yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you, believe you're fully informed about your case?
Yes, sir.
Okay. And you understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. And we'll go over them, then at the end, I'll ask you to understand them, okay? You have the right not to testify against yourself. No one can make you say anything, right to speed trial, but jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called testify against you, right to produce evidence, right to call witnesses in favor, right to appeal this matter to a higher court if you lose. And right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges. That you understand that by entering a guilty plea, that you give up those rights. So, you understand that?
Yes, sir.
Okay, now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to. Understand that you can fully complete the diversion program, which are diversion. You be brought back to the court for the vote to pre-trial diversion investigation, or sentencing hearing, pre-sentence investigation board. You'd be a convicted felon and that could be used against you in the future. You understand that? Mr. Stockton, what is the Commonwealth's recommendation? You step you up. What is the Commonwealth's recommendation?
Your Honor, in 24 CR 25, Ms. Cory will plead guilty to operating a motor vehicle with alcohol concentration above 0.08 or otherwise impaired. She'll serve 7 days in jail and pay a $200 fine. Also, in 24 CR 25, she will plead guilty to fleeing and evading the first degree on foot and receive a sentence of 5 years. In 24 CR 26, she'll plead guilty to operating a motor vehicle under the influence. First offense, receive a sentence of 7 days in jail and pay a $200 fine. She will also plead guilty to assault third, receive a sentence of 5 years. The two DUIs, 7 days in jail, shall run concurrently for a total of 7 days in jail. The 5-year sentence shall be probated, balanced, supervised for 5 years. She'll enter and complete a 90-day rehab facility arranged through her attorney and by agreement with the Commonwealth. She will receive credit for time served if she has any, and obtain gainful employment or do community service.
Can you understand that the DUI is enhanceable too? If you had another DUI, both of these could be used in the future against you. Understand that?
Yes, sir.
Are you pleading guilty to the acts charged in the amended indictment because you did commit those acts?
Yes, sir.
Okay. You plead guilty of your own free will for no other reason. Is that correct?
Yes, sir.
Okay. When your constitutional rights explained to us, you still your desire to enter these pleas and allow the court to fix your punishment within the range permitted by law. Is that your signature on the offer?
Yes, sir.
Okay, I'll accept the agreement and sign the diversion. Now, how many days does we have?
She's actually got 22 days in already.
Okay, so she's good to go.
She's good to go.
Okay, you need to just meet with a probation and parole officer there, give them the information necessary. Is she finished all those DUI forms? Let's go with those.
I will with her.
Now, what about the rehab situation?
We're trying to find one that accepts her insurance. She completed 6 weeks already at Sky Hope through the district court before she was indicted. And so we're just trying to find one that will take her insurance because she had to leave Sky Hope to come here for the arraignment.
So can she go back to Sky Hope? Why?
Because she left. And once you leave, they won't let you come back. She couldn't go back after she came over to the arraignment.
Yeah, between the arraignment today was the plea.
Right. Between the arraignment and today, she's been free.
Okay, that's what I'm asking. You
I'm sorry.
said between the
Sorry.
plea, and I thought, well, she just pled today. So Mr. Stockman, what do you have to say about this?
She's saying she can't go to treatment.
No, she said
no.
she was in treatment for 6 weeks.
Yeah.
Then she had to come here for her arraignment. And they wouldn't let her go back, and she's been free since the arraignment till today when she entered the plea, and they don't have a place set up for her yet.
I guess when you want to set up, because part of the plea, and I was talking to the officers, they wanted to treat.
Right.
That was the
Yes.
reason there wouldn't be any jail time, any addiction. So I think we need to make arrangements.
Oh, sure.
Yes.
Yeah, we're just
I-
Well,
calling her out.
I know, but when are you gonna make, you know,
She's been trying since we signed this or since we went over this last week, Your Honor. It's just a matter of with the holiday and with her insurance. Because it's Tennessee insurance. So she may be,
Hanging in mind the situation, she had a difficulty in bringing it back from the court.
Yeah. And I told her that probation parole has resources too, to get her into rehab.
Well, the problem I have is anything happens in the intervening time. And she's not in treatment the way she wants to. And I pick up the Clinton County News. I know this young lady well. She worked for one of the lawyers here in town. I hold her in high regard. But I don't want to I don't want to pick the newspaper up and find out something's happened to her.
Yes.
You know what I mean? And we didn't know about it. Yes, I'm not saying there will be anything happen, but out of abundance of caution,
Well, we didn't put her in jail for a day because if we put her in jail for a day, I'll get 6 different letters from rehab on the take. I mean, and I'm being facetious, that's what's happening. Somebody has a terrible case, I'll get all the letters from rehab, they're ready to take it, you know what I'm saying?
Do you have any in mind?
Yeah, I've been in contact with a few. There is Journey Pure in Bowling Green. I actually have a call scheduled with them later today. And
Well, meet with probation and parole and you keep up with him on what you're doing. You don't need to dally around between now and then. And between now and the time you get into rehab, I'd like to do a self-imposed curfew. Just go to, are you working anywhere now?
I had been helping my father some, however,
Well,
my
just,
husband,
the routine work, church,
right.
doctor, that sort of thing. And it's, or they used to say in Monroe County, don't be out of driving around. You know what I mean? You meet with him. Okay.
All right, thank you, sir.
Okay.
Thank you.
Where's the deal?
I'll go over them with her.
Well, you gotta
We
do
haven't seen
it.
him yet.
Well, she's gotta do it before she can enter her plea.
Okay. The Commonwealth did give us, but we'll go over it right now. That's not a problem. But I'll
Before she
let you-
leaves, she will figure you out.
Okay.
Yeah, I'm gonna get
Stephanie D. Salento. I'm sure I didn't pronounce it right. D. Celestino.
Celestino.
D. Celestino. This is 24 CR 0012. State your full name, please.
Stephanie DeCelestino.
Okay, were you born in 1979?
Yes, sir.
Last 4 digits, social security number 3011.
Yes.
You're here for a pretrial conference.
I'm gonna take the lead. The Commonwealth had agreed to pass this case. At this point, Ms. Delestino is prepared to make a payment in full to
What is
cover
the
the
case
arrears.
about?
It's child, or this is the case where $3,000 of the bonds applied last time. I think the other $1,000 will be applied, is that right? And then there's a balance left of $2,400, $43, but she pays it off, I'll dismiss the case. Okay.
You got it with you?
She does, Judge.
Just step across the hall and pay it, bring her seat here and
Hey, she would have to go to child support office, Judge, with it being, I would guess. I don't know if she can pay that to clerk's office.
show her where it is. Can you show her where the child support office is?
I can, I think I will.
She bring her seat back up there. Okay. They'll be here at 1 o'clock. They'll be here at 1, so you might want to walk down there and get your seat and you get the case dismissed and be on your way rejoicing. Okay. Okay. Charles Dickin. One of the deputies, one of the bailiffs will show you where the child support office is, right? Charles Dickin, you want to come around? Are you Charles Dickin?
Yes.
You born in 1961? Last 4 digits of your social security number are 5978. Is that correct?
Right.
Yeah. We're here on 24 CR 0043 and 24 CR 0044 for pretrial conference. Go ahead.
I think with this one, we're going to speak to the sheriff about.
I'll give you one more pre-trial, no, I'll get a trial date, if that's all right.
You want to have, you want him there for negotiation day?
Yes, Your Honor.
Okay, you to be in Burkesville at the Justice Center on July 31st at 1 p.m. And then your next court date will be here on August the 8th, okay? At 9 a.m.
Larry, got that down for the Charles.
Michael Lyans. Commonwealth versus Michael Lyans, 24 CR 008. Are you Michael Lyans?
Yes, I
Are you
am.
born in 1960?
Yes, I am.
That's 4 digits. Social Security number 3813.
Yes, sir.
We're here for a pretrial conference. What is the Commonwealth?
We can continue this, Your Honor, because this involves he's been charged with receiving stolen property of firearm. And I've tracked the owner down, I believe I can get him down here for the trial, so I'll have one more pre-trial, and we can issue a plea, I'll say it.
Negotiation day. You want a negotiation day?
Yes.
Negotiation day, you'll be in Burkesville on July 31st at 1 p.m. for negotiations, and you'll be back here in court on August the 8th. Both those are conditions of your bond. You understand that?
Yes, sir.
Okay, thank you. Norris Nagel. Some active warrant out, Mr. Stockton.
Yeah, I'll take care of you.
Okay. Wanda Neal. Yeah, I'm gonna say you are, I looked at your affidavit, you are eligible for public interview. Here for the purpose of arraignment. You were born in 1974. Last 4 digits, social security number 7635.
Yes, sir.
You have the right to remain silent. Grand jury of Clinton County has returned an indictment charged with operating motor vehicle under the influence in possession of controlled substance methamphetamine. Do you understand what those charges are, Mr. Bailiff?
Yes.
You acknowledge the identity of your client, received an indictment, waive formal reading and arraignment, counsel, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Ms. Neal, you'll be in Burkesville at July 31st at 1 p.m. for a pretrial for negotiations, and you'll be back here on August the 8th for the next court date. Both of the conditions you're bound. Yeah. Marion County, let's call this a Marion County case now. There was a time zone problem. Commonwealth of Kentucky versus Joseph Wallace. Are you Joseph Wallace?
Yes, sir.
Do you have an attorney?
No,
Pardon?
no, sir.
Do you have an attorney?
No.
Judge, if I may, the Department of Public Advocacy, I think represents Mr. Wallace's wife. And I think due to the conflict, so thought Mr. Cross
I
would
don't-
represent
I can't
Mr. Wallace.
I can't understand what he's saying because of the microphone. Yes or no, do you have an attorney?
Yeah, David was representing me. I don't know if he is now or not, you know what I'm saying?
You want?
Mr. Wallace.
You represent Joseph?
Mr. Cross, are you representing Mr. Wallace?
Joseph Wallace. Mr. Cross says that he's not representing you. He's here.
I think he had to withdraw because of conflict.
Yeah.
Okay. I thought I guess I was confused on the conflict. I guess DPA will also have a conflict, so I'll try to get Mr. Wallace conflict.
Will you stand in for arraignment?
Yes,
only?
Judge, certainly.
We're gonna get a lawyer to stand in for arraignment for you, Mr. Wallace, and then they'll be in contact to get you your own lawyer if cause of conflict. You understand what I'm saying?
Yeah.
Okay. The grand jury of Clinton County has returned an indictment charging you with trafficking and controlled substance second offense. Do you understand what the charge is? I'm not asking you if you did or not. You understand what the charge is?
Yeah.
Counselor, do you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, I'm signing a reciprocal discovery order on Mr. Wallace, so they'll get you the information. And the Office of Public Advocacy will be in contact with you. I'll go ahead and schedule you to be in Burkeville on July 31st for negotiations at 1 p.m. And then back here in Clinton Circuit Court on August the 8th. Both of those are conditions of any bond that you might have. And your new attorney will be responsible for doing transport orders, okay? Thank you very much. Thank you, Marion County.
Thank you.
Timothy Peran.
Got a plea, Your Honor. Felony plea.
Commonwealth of Kentucky versus Timothy Peran, 23 CR 0064. Are you Timothy Peran?
Yes, sir.
And you born in 1970?
Yes, sir.
Last four digits, social security number 7334.
Yeah.
A motion's been tendered that says you wish to enter a plea today. Is that correct?
Yeah.
Are you currently under the influence of drugs or alcohol?
Yes, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 23 CR 0064?
Yes.
Is your judgment impaired today in any way? Is your judgment impaired
No.
today? You know what's going on?
Yeah.
Okay. Have you discussed the charges with your attorney and are you satisfied with his advice?
Yeah.
Have you reviewed the evidence the Commonwealth has against you? Do you believe you're fully informed about your
Yes, sir.
case? You understand you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution before I can proceed. I need to know that you fully understand those rights, sir.
Yeah.
I'm gonna go down through them at the end. I'm gonna ask them if you know what they are. You have a right not to testify against yourself. No one make you say anything. You have a right to speak trial by jury, the right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, have process issued from mail or attendance. You have a right to appeal this matter to higher court of reviews and have a right to be part of the Commonwealth's prevent unreasonable doubt that you're guilty of charges against you. Understand it, but entering a guilty plea today, you give up all those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may plain range sentence provided by law. I do not have to accept any recommendation. Prior to accepting your recommendation, I will review the precinct's investigation report, medical probation, parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you'll have the right to withdraw your plea and go to trial. You understand that? You step to your left here, step to your left. Mr. Stockton, what's Commonwealth's recommendation?
Mr. Perigin will plead to the amended charge of possession of controlled substance first degree. He'll receive 3 years, probated for 5 years, probation to be supervised. He'll serve 100 days in jail, receive credit for 86 days. Once he completes the additional 14 days, he'll serve an additional 60 days home incarceration. All evidence in this case will be destroyed. He'll obtain, maintain gainful employment.
No. Is that what you agreed to?
Yes, sir.
Okay, is that your signature on the docket there?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the amended indictment?
Yes.
Okay, you're doing so of your own free will.
Yes, sir.
You're waiving your constitutional rights, you're gonna allow the court to fix your punishment, is that correct?
Yes. Yes.
And understand after this guilty plea, any future convictions of felons you might have could be enhanced as far as a penalty under the persistent felony offender law, correct? Y'all accept the agreement, order PSI, and schedule a hearing, a sentencing in this matter for August the 8th. Now, what about the remaining days he has to serve?
Like 14 days, I think he's prepared to go with day one.
Okay, well, you meet with the probation parole officer and then you be in custody, okay?
Then we're ready to get a call, we'll set it on the car.
Kathy Sue Phillips. Kathy Sue Phillips, not here. Does anybody know where Kathy Sue Phillips is?
I don't even know.
Judge, I represent Miss Phillips. I don't know what happened with this particular case. I think it got off docket.
I'll tell you what happened. We were promised that a suppression motion was gonna be filed, and it was never filed, and it got lost in the cracks. And after another case got lost in the cracks here, I've been going back through my files so we can get back on the docket. I ain't fussing at you.
Well,
That's what happened.
Was it my predecessor?
I know it was you, I think. Somebody told me they was gonna file a
It
suppression.
doesn't matter. It doesn't matter.
It doesn't matter, but I was gonna say, Judge, I received the motion to redocket for pretrial a couple of days ago. I don't know where this
You have
is.
Kathy Sue Phillips at Burkesville on July 31st for negotiation. And then next year, on August the 8th, her next court appearance, if she doesn't come to Burkesville on the 31st, get in contact with me and I'll issue a bench warrant.
Yes, Judge.
That's all we would have done if she'd been here today.
That's what.
Jamie Scott, active warrant, Jamie Scott.
NCI, so.
Maggie Scott. Arraignment. Mary Brown. Will you raise your right hand? You solemnly swear or affirm that you conduct your duties as to the grand jury of the Clinton Circuit Court that you hereby consider all matters involving protected from the Constitution, Commonwealth of Kentucky, United States of America, and keep everything confidential. Thank you very much. I'm gonna go with the votes. Test of the votes. Commonwealth versus Maggie Scott, 24 CR 0053. Are you Maggie Scott? Born in 1984. Last 4 days of social security number 3307. You have a right to remain silent. You hear the counsel. I'm going to just read the indictment by title. The grand jury of Clinton County charged you with possession of a controlled substance, first degree, possession of controlled substance, first degree heroin, in addition to that. Operating under the influence, careless driving. Do you understand those charges? Okay. Mr. Cross, you acknowledge the identity of your client received the indictment, waive formal reading your arraignment and pleading not guilty or reserving all pretrial motions.
Yes, Your Honor.
I sign a reciprocal discovery order. Commonwealth is required to provide you the information they have to help you prepare for your defense. You'll be in Burkesville at the Justice Center on July the 31st at 1 p.m. for negotiation. Then you'll be here back in court here on August the 8th, your next court appearance. Both of those are conditions of your bond. You understand that? Okay.
Okay.
Sharon Sidwell. Sharon Sidwell. Commonwealth versus Sharon Sidwell, 24 CR 0054. Are you Sharon Sidwell? Are you Sharon Sidwell?
Yes,
You born in 1970.
yes,
Last 4 digits, social security number 7041.
yes.
You're on 24 CR 0054 for the purpose of arraignment. You have a right to remain silent. You represent by counsel. If there's anything that you don't understand, step away from the podium and quietly mention it to your attorney. The grand jury of Clinton County is returning indictment charging with improper display of registration plates, not having your license in possession, operating under the influence, possession of controlled substance, possession of marijuana, possession of drug paraphernalia, improper registration, failure to maintain insurance. You understand those charges?
Yes.
Counselor, do you acknowledge the identity of Ms. Sidwell, received indictment, waive formal reading, and arraignment, enter plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
Ms. Sidwell, you need to be in Burkesville on July 31st 1 p.m. for negotiation day. Could I have another opinion? The spring on this one seems to be. See if you can get the work. Yes. Be in Burksville on July 31st at 1 p.m. for negotiation and be back here on August the 8th at 9 a.m. The next court appearance. Both of those are conditions of your bond. You understand that?
Yes, Your Honor, thank you.
Thank you.
Commonwealth versus John Smith. Did you get to work? Yeah, good. Where's John Smith? Anybody know? Hey, issue benchmark. Where's Mr. Cross? You have John Smith?
He's here. But he is here.
Yeah, they brought.
Well, it's time for him to go from here. Did y'all have a transportation order on Mr. Smith?
Jail went back.
Why?
We didn't have.
Where is he incarcerated at?
Russell County, Your Honor.
There wasn't a transportation order on him.
Your Honor, it's a little confusing because I tendered one like 2 weeks ago for him to be at the negotiation session and today, and somehow it never, I don't know what happened. And I think the Commonwealth did one too, but it just slipped through the cracks. So that's what's happening.
Commonwealth versus John Smith, 24 CI 00001. Are you John Smith?
Yes, Your Honor.
Born in 1987.
Yes, Your Honor.
Last 4 digits, social security number 5238.
Yes, Your Honor.
Pre-trial conference, where you at?
Well, I filed a motion for a competency hearing.
You wanna move over that way just a little bit?
And I need to know if we need to have a hearing on that first.
We're stipulating on that, Your Honor. Spoke with Mr. Smith, and we're satisfied that he's competent. So there's
So where are we
stipulation.
here?
Well, since we had, it's just now being turned competent, I'd like to have a pre-trial and negotiation.
July 31st at 1 p.m.
Your Honor, I believe that's appropriate. I do want to raise the issue to the court that Mr. Smith's been incarcerated.
So let me finish with this.
I'm sorry.
July 31st at 1 p.m. for the negotiation, and next court day is August the 8th here. Now, you want to say something about his bonds?
Your Honor, it's been in some time. He can make a decent bond.
What is the charge?
He's charged with wanton endangerment, DUI, and vehicle collision.
Follow the vehicle. Wasn't serious. No serious injury. No real injury.
He may bond in this case, it's because of the district court amended.
Oh, okay.
There's no bond in the district court.
No bond in difference.
Yeah.
Okay. We'll see about it. Okay. And that's including how much is it? So no bond. Okay.
No bond on the bond.
Oh, okay. Thank you. Okay, I'll see if I can do something. I'll get it. Okay.
Okay, thank you, sir. Okay.
It's.
Okay, we're to go to Russell County at 10, so we got a 12-minute.
We have one more matter out of custody. One more matter out of custody, if we could take it up.
Okay.
And I asked to be added on today. Christie Key, she can come forward. Okay, what that is.
What's this lady's name?
Christie Key. I had scratched it for the file, race.
Is that with a C or a K?
Say.
Christie Key, are you Christie Key?
Hi.
What's the year of birth?
8877
1977. What's the last 4 digits of social security number?
9043
9043. What's that?
Your Honor, Ms. Key was in specialty court. She was administratively discharged for health reasons. So I'm asking that she be placed on regular supervision at this time and ruling her in order.
She need to be interviewed by the,
Yes, you'll need to meet with Mr. Payne.
well, about the clinicians to see if there's anything else she needs to do.
No, I think she's past that hurdle in the specialty court. But Mr. Payne can keep an eye on her.
Okay, I'll sign the order.
Thank you.
This is.
How about Daniel Morland? We ready on Daniel Morland now? Where's his person? What is that? It's just an investigation for Mr. Morland. I'm sorry.
Is that all the time?
Y'all find Mr. Pennington? Is Mr. Pennington around? Okay, we're back on Commonwealth Kentucky versus Daniel Morland, which is 08 CR 0078 and 79. Have you had an opportunity to look at the pre-sentence investigation report done by probation pro?
Yes, Judge.
Is it substantially correct?
Judge, with regards to the time credit, I don't know if I can answer that question, yes or no. I checked with probation and parole, and there is no way for them to account for Mr. Morland's 10-year sentence in the custom credit. So we're showing 700 days. I know that is not correct, but I don't know if there's a way for that to be cured within a PSI. Which Judge raises to the, with except that, the PSI.
Wait, Mr. Stock, Mr. Cross, get away from Mr. Stock.
Well, he's contaminated, but I just.
No, it's not a matter of contamination, it's a matter of distraction. You're welcome. Now, before we were interrupted here, there's some discussion about whether the pre-sentence investigation board is substantially correct. They want to make a reservation concerning the calculation of the days because of unusual circumstances. Is that correct?
Yes, Judge.
I've got no problem. Okay, now we're going to proceed with sentencing. You have a statement you'd like to make on sentencing. You move to the left here, sir.
I would just ask at this point in time, based on the Supreme Court ruling, Your Honor, that the portion of the sentence that the sentence can be enforced. And that was the agreement. That's what I'm asking the court to do. If at this point in time, if Mr. Morland withdraws his plea, we can start over. I mean, that's where we're at.
And Judge, I think this is where you wanted me to re-argue.
Does he want to withdraw his plea?
Judge, first, and it's on the 14th page of Mr. Morland's decision. This was actually the paragraph that I read through on the record in court. Very brief, Judge. But given that we have held this issue as one of illegal sentencing and is now failure to follow the statutory parameters when probation is available, we hold that the remedy in this case is remand for resentencing. This case is more analogous to Fawn than it is to McClanahan. The solution obviously obviates any claim by either Morland or the Commonwealth that they have been deprived the benefit of their original bargain, because both parties, along with the trial court, may now seek a new bargain on how Mr. Morland shall serve his sentence, including, if agreed to by the parties, a new period of probation in conformity with the statute. I think the Supreme Court is.
Well, it said if y'all reach an agreement, that you got an agreement. If you don't, you have a new trial. That's what they're saying.
And
You agree with that?
no,
Well, what am I gonna do if y'all can't agree?
then that will be the remedy. But we've not had a chance to agree or not.
Well, I'm asking you if you've reached an agreement, and your answer is no, you haven't reached an agreement.
We haven't had the opportunity to try.
Do what?
We haven't had the opportunity to try.
To try to reach an agreement? I thought you meant to try the case. I didn't know. When you said try it, I thought you meant that you had an opportunity to try it, and I was gonna give you an opportunity to
And,
try it.
and Judge, I guess this is a secondary issue, and I don't know what you're about to say, so I can only speculate. But if we're going with Mr. Stockton's approach and the court will sentence Mr. Morland to 20 years with the uncertainty of the credit, the 10-year credit sentence, that might put him in a position where he's serving 10 years. So
I mean, this is
this is a case of first impression.
This is a different branch that I'm involved in. I'm in the judicial branch, and I do what my bosses, the Court of Appeals and Supreme Court tell me to. This was not my case.
Nor mine, Judge, nor
Okay.
mine.
But, the parties all agreed with learned counsel that this was to be accepted in the court citizen proper sentence. And I agree with the fact that if there is an illegal sentence, that you can't waive it by accepting. I agree with that, okay? But now the only choice I have is to listen to the arguments and sentence him. Or if he believes that he's not going to get the benefit of the agreement by the two parties agreeing, then we set it for trial. If you want some more time to negotiate it with the Commonwealth, I'll give you that.
And I mean, if Mr. Stockton is unwilling to, I mean, I think that gets us past the term, but
He started it. That's where he started, okay?
that's where we began without Mr. Morland. So Judge,
Okay,
I'm fine with
let's
that.
set a negotiation date. We'll transport him down to Burkesville. Or would you rather have him on a different day or?
No, that's,
Okay, have him transported to Burkesville since you're gonna be there anyway.
Yes,
On
Judge.
the 31st of this month at 1 p.m. And then his next court date will be here on August the 8th. And y'all can inform me before then, if you would, Mr. Stockton, if y'all would inform me before then as to whether or not you reached a negotiation that date, and I'll give both of you an opportunity to educate the court with a brief as to what we're gonna do on that sentencing day, since it is an unusual case, okay? Does that
Thank you, Your
sound
Honor.
right?
Yes.
Okay. Amy, will you fill this out for that? I'm gonna fill it out the next 2 dates. He's got to appear somewhere, okay? And then that doesn't mean that we won't have to, I guess we'll still have to have a transportation order that we'll send to him, right? Okay.
And
Miss
Your Honor,
Poria, is Miss Poria, is she leave? Well, she previously said she understood the DUI, but let the record show that she and her attorney was just present. And did the correct papers on DUI as far as hands.
Just if I may very briefly, Mr. Stockton actually brought this to my attention while we still have Mr. Morland. I think this raises an issue now as to the appropriate facility where Mr. Morland should be housed. I think now that we're in a trajectory where this is going to be negotiating, the court has yet to re-sentence Mr. Morland, so.
Well, I was ready to.
According to my system, he's still a state inmate.
Okay, then that.
Okay, well, let's move on here.
Are you done with him?
Yeah,
Okay.
thank you.
I'll give you a credit later. He's going to do it. He's going to set it up.
Back up, being stormy.
James Armstrong. James Armstrong. Commonwealth versus James Armstrong. Is your bond set on James Armstrong? What is the bond? We never had been arrested before.
Your Honor, can Mr. Armstrong sit down?
What's the bond? Has he made it yet?
No. We hadn't been aware there was a bond posted or additional motion for.
Are you James Armstrong? Sir. You born in 1963? Last four digits, social security number 8043. You're here for the purpose of arraignment in 24 CR 035. The grand jury of Clinton County has charged you with assault in the first degree. You understand what that charge is? You acknowledge that you received an indictment. Then your client waived formal Regan arraignment, enter plea not guilty.
Yes, Your Honor.
Do we also have the case of 24 CR 0013 for pretrial conference? What does the Commonwealth have to say?
Well, we've not negotiated this case, Your Honor, because Mr. Armstrong has been in the hospital or been unavailable. And I filed a motion to have him put back incarcerated because he's never made bond. And the only thing Mr. Cross furnished me is regarding his illness was with a statement from Carol Denny, who's basically said if he can't make his appointments, he's in jail, he's gonna lose his insurance. I don't think that's relevant as regards bond. And then I was furnished thing where he had 3 more doctor's appointments on July the 3rd, July the 24th, September 11th. So I have no medical documentation in regards to illness or injuries. I've not received any of that. And what happened was they had him stroke at the hospital, had his stroke at the jail. He was released and taken to the hospital in Lexington. It was fine, but he never made bond. I don't know, I guess the court, I don't know if the court changed the bond or what. But on the books, it still says it's a 10,000 gallons and 20,000 property bond.
Your Honor, in response to Mr. Stockton, I'm here to practice law, not medicine for Mr. Armstrong, but I do believe certain things are just evident as to his condition. He can make a bond regarding his own real estate.
Where does he reside
He's
now?
residing with his sister Teresa Davis. And that's where he's been since he was released from.
Who is the alleged victim?
It was his wife at the time. I think they're divorced, maybe divorced today.
And it's a serious dance. If the allegation proves serious.
Serious allegations, I will agree on that, and there were some injuries, yes. As I was saying, Mr.
Well, I'm not casting any aspersions on Mr. Armstrong or his family, but I remember the case where Wayne Patterson was always going to court, and he's deceased now, and I hate to talk bad about him, but he always come to court and he told his oxygen tank with him. And then when Jim Guffey went out to arrest him one time, he jumped up out of the couch like he was an Olympic athlete.
I
So
remember the film.
So I would like to have some verification that he's that either.
I know, but I don't know what in the world that's got to do with Vince Armstrong. It ain't got a thing to do with it.
What I'm saying is I've not been furnished anything.
Well, you were involved in both of them as
Yeah,
well.
Well, Clay Hunley accused me of having an oxygen tank in my office when we tried Ricky Savage, but that was an acquittal, by the way. And,
But if he can make a bond, that solves the problem.
He can make a
I just
bond.
don't want him treated any different.
that's in the middle of talking. He owns his place. I can go next door and see if it's $20,000. It may not be. It's not much of a place. But we weren't aware there was a bond. So he'll make a bond today, but we may have to
We just
lower it
arranged it
slightly,
just then, right?
or I'll get him to raise
Just-
his
just-
I just want
First degree, yeah, and I
Understand.
first degree assault.
May I go next door?
Wait a second. I just arraigned him on first degree assault. Is that correct? Did you
Yes.
hand him the indictment? You acknowledge the identity of your client received indictment, wait formal arraignment, reading arraignment, plead not guilty. What's his bond?
There's 2 cases, 10,000 cash, 2 controversy on each. That has not been for a total of 20,000 cash. We not.
Which will be 40. Now, his place will not assess for that, but I can go next door and report back to the court in
Well,
two.
I tell you what, I'll let him do on both of those bonds for 10,000 2 times property. So $20,000 worth of property, he can sign that. Now, I also want him on a strict curfew. And where is he leaving? At whose address?
At our sister's.
What's her
On
address?
Third Street, 1002 Third Street.
Okay, well, he can't leave that house,
Except for doctor's report.
doctor's appointment or church.
Well, he won't be going much of anywhere.
Well, you don't know that. I'm not, he can go somewhere, but those are the 2 places he's allowed to go. And you say he's not going anywhere, then he shows up. Well, I didn't think he'd go there. I know, I mean, I'm
Well, he
sure you
can't
don't
see and
think
he
he's
can't
going.
walk and he can't drive. So if he gets somewhere, it's going to be real
Well, he might have
creative
a
on somebody.
miraculous recovery. I hope he does have a miraculous recovery.
He's been
But in
there.
any event, he's to be
That's
in-home
about-
incarcerated at your sister's house. The address was given. Did you get the address?
Yeah, what are you worried about, huh?
No contact with anybody, with the victims at all, none, got the alleged victims, no contact. Okay, is there anything else?
We can leave him up here for a little bit to sign the paperwork on the bond. That would be
And
good.
negotiation day will be on the 31st in Burkesville at 1 o'clock, or if y'all can work out something else with the Commonwealth.
Thank you, Your Honor.
Wait just a second. And his next court date will be here on August the 8th. Mr. Stockton?
Yes.
I've set the negotiation day for the 31st, but if you become convinced that it's too difficult to get him over there, you can make another arrangements with Mr. Cross as far as negotiations.
That is fine.
Okay, thank you
Thank
very
you.
much.
Just wait right back there with him and I'll do the paperwork.
Now, does that conclude the out of custody docket? Christie Beatty, did Christie Beatty come?
She's coming in.
Judge, if I may very briefly, I think Mr. Cross represents Ms. Beatty, but Ms. Delestino did come back. She's already been to child support to
Did you make that payment down there? Show the receipt to the Commonwealth and be on your way, rejoice. Miss Beatty, is that where we're at? Christie Beatty?
She's not showed up.
I thought it said she was. Okay, let's go to Russell County. Not all.
Yes.
And Roder is supposed to be on too.
On Mondays.
Okay, well, let's go off the record till we get Russell County on the line.
So I had 4 people left the court. And it's going on to.
We have a report on them right custody.
Yeah, let's go back on.
They both responded, said they're working.
Okay.
Yeah, Miss Kathy Phillips came in, she saw this, her case being called on YouTube, so she came in. So I just put her up here and get her recognized, so she'll be in court.
Commonwealth versus Kathy Sue, is that right? Phillips. 23 CR 003, born 1979. Last 4 digits, social security number 6652. You're supposed to be at Burkesville, is that right?
July 31st.
July 31st at 1 o'clock for negotiation, and back here on August 8th for your next court date. Welcome to issue your bond. You may be on your way rejoicing.
Thank you.
Wayne County, gonna go to Wayne.
Yeah. All I do is
It's screened.
Then we'll come back to Russell. John Brown.
well, we're trying to get it. We ain't got no help.
John Brown.
Yeah, there we go.
You're okay.
Can you hear me?
Which one of you is John Brown? Okay. We're on 23 CR 0059 for the pretrial conference. Mr. Brown, were you born in 1979?
Yes.
The last 4 digits, social security number 2532.
Yes.
Okay, what do we have here, Mr. Stockton?
It's a felony plea.
Mr. Brown, I understand that you wish to enter a plea today. Is that correct?
Yeah.
Are you currently under the influence of drugs or alcohol?
No.
Is this free plea, freely and voluntarily given?
Yes.
Are you the same person named in indictment number 23 CR 0059?
Yes.
Is your judgment impaired, sir, today in any way?
No.
Have you discussed this matter with your attorney, and are you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you?
What was that?
Have you reviewed the evidence that the Commonwealth has against you? Feel like you're fully informed about the case?
Yes.
You do not have to enter a guilty plea today. You understand you have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm going to go over them, then I'm going to ask you. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury. You have to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. Your right to produce evidence, your right to call witnesses in your own favor. And that process issue to compel their attendance. You have a right to appeal this matter to higher court if you lose. You have a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering your plea today, you waive those rights. You understand that?
Yes.
I may consider the Commonwealth's recommendation, or I may apply any range of sentence provided by law. I don't have to accept the recommendation. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation? Doctor, did you come
Mr.
forward?
Brown, plead guilty to possession of controlled substance first degree, receive 1 year to serve. Commonwealth opposes probation. All evidence in this case be destroyed.
Is that what you agreed to, sir?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes.
You doing so of your own free will?
Yes.
Knowing your constitutional rights, which you previously waived, is your desire to allow the court to finish within the parameters allowed by law.
Sorry, you cut out.
Is it knowing your constitutional rights that I read to it? It explains it's still your desire to give up those rights, and allow the court to fix your punishment within the range of parameters permitted by law.
Yes.
You know, you understand after entering this guilty plea, any future convictions of felonies could be enhanced under persistent felony offender law.
Yes.
You have the paperwork.
Should have been one on how I'm sorry.
Sir, is that your signature there?
Yes.
I will accept the plea, order pre-sentence investigation report to be done by probation and parole, and schedule you for sentencing on August the 8th.
Hey, John, somebody will be over to the jail to see you.
Okay, all right. Mr. Pennington?
That was the probation and parole officers telling us somebody from be over there to get the information and get the process going, okay?
And Mr. Brown, that second count was dismissed that we talked about
Okay.
yesterday.
Okay, all right. Thank you.
David Carter. David Carter. Commonwealth versus David Carter, 22 CR 0062, 63, and 64, and 22 CR 0078. All of them are probation revocations. Mr. Stockton.
Yeah, all those total up to 17 years and 6 months. We were here in court, I think back in April, Mr. Carter absconded and he was given a 60-day sanction in lieu of revocation. Once he served that 60-day sanction, he was brought in and drug tested. He was positive for meth, THC, Suboxone. He was given to see the SSC. He was supposed to go and complete outpatient services, and he absconded again and didn't complete his service. Didn't enroll.
Stipulate.
Judge, I'll stipulate to the acts, Mr.
Okay, you can argue that. Stipulate the facts.
Yes, and Judge, Mr. Carter actually has bed letters, he tells me, with Crossroads and Hart. He's looking to do some long-term rehabilitation, minimum of 1 year. And he has indicated, there's also a revocation going on in Wayne County. He's indicated that Wayne is agreed to.
Well, I'm gonna revoke him here. And the reason I'm gonna revoke him, it's kind of like a guy that stole my dog. I tell you about him. He promised he's gonna bring it back. Anybody will steal your dog will lie to you about whether they're gonna bring it back or not. Now, he's absconded twice. And I just can't do it. Hopefully we'll get some treatment there. I'm not saying he's a bad person or anything. He just is not compliant. So he's got to go. Okay.
Yes, Your Honor.
Thank you. Jesse Pitman. Jesse Pitman.
Here I am.
Commonwealth versus Jesse Pitman, 18 CR 0074 and 23 CR 0037. You were born in 1986, Mr. Pitman.
Yes, sir.
That's what it is. Social Security number 5673. Now, what does the Commonwealth have to say about this? It says on for review.
Your Honor, this is the case where Mr. Pitman was on parole.
Yeah.
He was indicted for assault and other charges. The victim in that case had difficulty finding her, and I'll just say ultimately that case was dismissed. In the meantime, his parole was revoked, and I think he was deferred for a year.
Yeah.
Yes, sir.
I don't know when he's due to get out. And Mr. Pitman was represented then by DPA, and then he began representing himself, and he was on negotiation day. And I agreed at the negotiation day that if the court would agree, I would set aside the previous plea under 6002 and let him enter a plea to unauthorized use of a motor vehicle to finish paying the restitution. Now, that's what I ended up agreeing with Mr. Pitman on that day. It was last week, I think.
I don't think I have the authority to go back. What authority do I have to go back?
Well, we'd have to have a good reason to set the plea aside, and the only reason I could think of was under some of the case law come out on thefts of vehicles, you know, it could possibly have been unauthorized use.
Ineffective assistance counsel.
Then Mr. Pitman's arguing ineffective assistance counsel, but I don't think that applies under 6002.
That's 1142.
That's 1142, and that has to be based back on, on appeal and 1142 motion rather than a 6002.
Well, that's why I filed 1142.
And I don't know when's he due to be on for parole.
He serves out 6/6 of 25.
So what bothers me about the case is the parole board has already acted upon it. And I think I have kind of a separation of power sort of situation. I don't think I can go back and set that aside. But I will enter an order denying your motion, Mr. Pitman, and then you can appeal that, and maybe the Court of Appeals will tell me I'm wrong on that, okay?
Your Honor, I thought that we agreed to vacate the sentence and me plead out to the other charges, what you said last time I met. And that's what you told me that we would do, that you would vacate it and me plead out to this is what you agreed to do for me. That's what you said the last time we was in court, Your Honor. That's the reason why me and Mr. Stockton got together and come up with that deal. You can ask Mr. Stockton, he'll agree to it. I mean, he knows I'm not.
I don't remember agreeing to it.
That's Mr. Stockton. She even told my mom, like my little girl.
Agreed to it, and my ruling is that I do not have the authority to go back and set aside that previous judgment.
You couldn't vacate?
Well, wait a second. Mr. Stockton has come forward and said he agrees with you. And he agrees.
Yes, sir.
But that still doesn't give me the authority to do it. And I say that I don't have the authority to go back and set that previous judgment aside unless there's a specific thing related to that judgment, and the parole board's already acted on it. So I don't know what the deal is, but you know, that's what my ruling is, and you can appeal it, okay? Thank you very much. Thomas Tucker. Commonwealth versus Thomas Tucker. Are you Thomas Tucker?
Yes, Your Honor, I am.
Were you born in 1986?
Yes, Your Honor, I was.
Last four digits of social security number 8482.
Yes, sir.
We're here on 24 CR 0034 for pretrial conference. What do you have?
Judge, the Commonwealth has agreed to pass this 1 month. There's some underlying discovery. I
A
need.
negotiation day on July 31st at 1 p.m. in Burkesville. And the next court date is August the 8th.
Yes, sir, Your Honor.
We'll talk to you, Mr. Tucker.
All right, thank you, Benji.
Wayne County, do y'all have anybody else waiting for us here?
No, sir.
Okay, then let's go back to Russell County. Thanks, Wayne County, your release. Thank you very much.
Thank you.
Let's go back to Russell County. Cory Barrett. Going to Cory Bard. How do you pronounce your last name?
Bard, B-A-R-D.
Okay. Cory Bard, 24 CR 0039. Mr. Bard, were you born in 1993?
Yes, sir.
Last four digits, social security number 0642.
Yep.
Okay, what do we have, Mr. Stockton?
He's supposed to be going to KCPC. Mr. Pennington asked me if we had a report, and I don't have anything from him. I don't know if he's been evaluated or not. I didn't know. If there's
Mr.
anything.
Baird, did they take you up for an evaluation, or Bard, excuse me, did they take you up for an evaluation yet?
Nope.
Okay, well, we'll try to get them cranked up on it, so they'll do that, okay?
All right,
So,
thank you.
just be patient.
All right,
Your
thank you.
attorney will come over and talk to you soon. Okay?
All right.
Tony Claiborne.
Yes, sir.
Tommy Claiborne.
Yes, sir.
Commonwealth versus Tommy Claiborne. 24 CR 0057 for the purpose of arraignment. You are Tommy Claiborne, is that correct?
Yes, sir, Your Honor.
Born in 1974.
Yes, sir.
Last four digits, social security number 0040.
Yes, sir.
For the purpose of arraignment, you have a right to remain silent and counsel is here. Present. The grand
Okay.
jury of Clinton County has returned an indictment charging you possession of controlled substance in the first degree. You understand what that charge is?
Yes, sir, I do, Your Honor.
Mr. Bailiff? Counselor, do you acknowledge the identity of your client received an indictment, waive formal reading and arraignment, enter plea with not guilty, reserving all pretrial motions?
Yes, Your Honor.
Mr. Claiborne will be in Burkesville on July 31st at 1 p.m. for a negotiation. The next court date will be August the 8th.
Judge,
Okay.
if I could briefly inquire as to Mr. Clayton's bond.
50,000, sure, and he was stating that, no one stated.
Just state inmate now.
Yes, sir.
He's a state inmate.
That answers that question.
I'm signing reciprocal discovery order. I think. Robert Comr. Commonwealth versus Robert Comr, 24 CI 0037. Are you Robert Comr?
Yeah, Robert Comr.
You born in 1975, Mr. Comr?
Yes, Your Honor.
Last four digits, social security number 2424.
Yes.
Here for pretrial conference, what do you have?
Judge, we have a diversion plea.
Mr. Comr, a motion's been tendered, says you wish to enter a plea today, is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 24 CI 0037?
Yes.
Is your judgment impaired today?
No.
Have you had an opportunity to talk to your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you?
Yes.
Do you believe that you have been fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea?
Yes, sir.
Certain rights under Kentucky United States Constitution. I'm going to go over those rights and then I'm going to ask you if you understand, okay? You have a right not to testify against you, so no one can make you say anything, right to speedy trial by jury, right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called against you, right to produce evidence, the right to call witnesses in your favor, and process issue and compel their attendance. You have a right to appeal this matter to higher court if you lose, and right to apply the Commonwealth to on reasonable doubt you're guilty of charges against you. You understand that by entering a guilty plea, you waive those rights. You understand that?
Yes, sir.
And I may consider the Commonwealth's recommendation. I don't have to accept the recommendation, but again, after I review the precinct's investigation report, I do not go on the recommendation and decide to give you a harsher penalty. You have a right to withdraw your plea and go to trial. Do you understand?
Yes, sir.
Okay. Mr. Stockton.
Your Honor, Mr. Comr will plead guilty to possession of controlled substance first degree, receive a sentence of 3 years, pretrial diverted for 5 years, supervised. He'll receive credit for 142 days of incarceration as of today. He'll also plead guilty to failure to maintain insurance, receive a fine of $500. He'll also be agreed to be assessed and follow all recommendations of the Social Service Commission. And he'll pay all fines and court costs at the discretion of the court. All evidence in this case will be destroyed and he'll obtain, maintain gainful employment.
Is that what your agreement was, sir?
Yes, sir.
Okay, have you previously been diverted in the last 5 years?
Not to my knowledge, no.
Felonies in the last 10 years, or are you currently on probation?
No, sir.
You understand that if you successfully complete the diversion program, the case will be dismissed, pre-trial diverted, you can have your record expunged. You understand that?
Yes, sir.
If you don't successfully complete it, you get brought back and forth, and I revoke your pre-trial diversion, you'll be sentenced and you'll be a convicted felon then, and that can be used against you in the future. You understand that?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
Do you do so of your own free will?
Yes, sir.
Okay, knowing your constitutional rights, explain to you still your desire to proceed and allow the court to impose the punishment. Okay, now I've got your document here. Can you find your signature? I'll show you the signature here. And is that your signature on there, sir?
Yes, sir.
Okay, well, I'll sign the agreement. Does he have his days in?
Judge, it was diversion, and yes, he's ready to be Comr.
So
He needs to come and see me on the 16th at 9 a.m. Central Time at the Monticello Probation and Parole Office.
16th, did you get that?
Yes, sir.
Okay.
9 a.m.
Mr. Stockton needs to be released today, is that correct?
That's correct, due to the amount of time he's got on the judge.
We'll go ahead and sign a release, unless you want to wait till tomorrow. You'd rather wait till tomorrow, you want me to let you out today?
I'd kind of like to go home today.
Well, I just want to give that test to see, hey, see if we need to get the evaluation for him or not, because we didn't want out today, you know.
Judge, if he's getting released today, he needs to report, if he's released today, if it's before 3 p.m., he needs to report straight to the Monticello Probation and Pro. If it's after 3, be there in the morning at 8 a.m.
Okay, I'm gonna release you after 3 p.m. today. You be there in the morning at 8 a.m., okay?
You'll be released after
They just changed the date here. Since you're gonna get released today, so just go straight to the probation pro office today, okay? Check
Today,
in.
okay.
Or closed. be
Now, I
there.
don't want any caveats, okay? Hell, it'd take an encyclopedia. You just go to the probation and pro office today as soon as we let you out, okay?
Okay.
Okay, thank you so much. Ashley Duval. I thought next thing would be you wanting to go over there and hold your right hand over your head and put your left hand in your pocket. Commonwealth versus Ashley Duval. Are you Ashley Duval?
Yes,
You born in 1987?
yes,
The last 4 digits, social security number 4575.
yes.
Okay. You're here today for a pretrial conference, but also for an arraignment. It's 24 CR 0048.
And just as a point, it's a pretrial revocation or diversion revocation.
Is there an arraignment too?
Yes,
Do you have a right to remain silent on this arraignment? The grand jury of Clinton County is returning an indictment charging you with operating a motor vehicle under the influence and wanton endangerment in the first degree 2 counts. Counselor, you acknowledge the identity of your client, receive the indictment, await formal reading and arraignment, and plead not guilty.
yes, Your Honor.
Okay, have a negotiation day on July 31st, next court appearance on August the 8th.
And Judge, with regards to the other case for Ms. Duval, that's 23 CR 49. The Commonwealth has agreed in lieu of revocation for Ms. Duval to go into the Clinton Specialty Court.
Well, if we can get everything right.
Well, and I was gonna say
But I'd like to tender a referral form to have her assessed and see if she qualifies. If that's all right with the court.
You know, and we got the other, is that before we do anything on the other case? Or?
Now, I would like to have her assessed, and that way on the negotiation day, I'll know if she's eligible.
Okay, that'll be fine.
Yeah.
I see where we have on the screen now. Where is that Marion County Detention Center? Rotor. Where is it? Are you Sidney Foster?
Yes, sir.
Mr. Duval, we're finished with you. Your attorney will be over and take a look. I'm gonna do a referral to drug court. I'll be right back to there. I'm going to Rotor Correctional Complex right now. Are you Sidney Foster?
Yes, sir.
You born in 1972?
Yes, sir.
Last 4 digits, social security number is 8733. You're here on 21 CR 00100, 23 CR 0022, and 23 CR 0043 with a motion for shock probation. What do you have?
correct, Judge, that's my motion, and with regards to Mr. Foster, he had received a sentence of 10 years on wanton endangerment charges. Just to briefly state the facts, allegations where he had, there was a altercation, a gun went off, went into a coffee table and through a wall. Judge, what I have is there were 2 victims in that case, Mary Lou Terrell, Kenneth Duval. Both witnesses, or excuse me, both victims, executed, they state identical. I, Mary Lou Terrell, I, Kenneth Duval. State that I have no objection to Sidney Foster receiving shock probation. I was a victim to the crime. Both signed 7/8/24 for Mr. Terrell and 7/9/24 for Mr. Duval. for the purposes of complying with Marshall's law. Judge, Mr. Foster's been incarcerated since March of 2023.
What does the Commonwealth have to say?
Your Honor, I would thought about considering shock probation in this case, but then when I conferred with Mr. Payne, he's parole eligible January 25, where he's currently incarcerated, he's enrolled in the SAP program. And I think he would greatly benefit if he would complete the SAP program. Of course, they're gonna parole him if he completes it. And if you release him, then he's gonna have, you probably want to put him in 6 months rehab. And I think he's better off being in the SAP program, completing that. So
Well, you better off on parole than with probation too.
that's my thinking.
And Judge, I didn't want the time we file this and that Mr. Stockton is correct on those dates and where Mr. Foster is at. Judge, he had actually come before the court wanting to go to long-term rehabilitation.
Well, what do you want me to do now?
Judge, we would ask that the sentence be suspended, Mr. Foster be allowed to go. He's actually asked for a 1-year rehabilitation, particularly Chad's Hope in my hometown, Manchester, Kentucky, which is a required 1-year rehabilitation. They don't take him on for less than a year. That way Sidney can get the treatment he needs, come back and be a productive citizen in society.
Well, I'll agree to do that if he goes into that one program for a year if he wants to. And you understand, Mr. Foster, you can stay where you are and probably get out in January, or you can go to Manchester for a year, and if you flunk out there, I'm gonna revoke you, you know? Which one you wanna do, you know?
I'd rather get out on shock and go to Manchester.
Okay.
I would just ask the condition that he stay in Manchester, not come back here unless he gets.
Well, I mean, I'll go ahead and do the shock. But.
Thank you, Your Honor.
I do that. Wait a second. Tell me, Mr. Stockton, about the weapon. What happened to
The
it?
allegations were that, Mr. Foster had been around town that day.
Get behind the microphone.
He went to Miss Belk's apartment and he was probably intoxicated. He had a 22 rifle that he went and purchased that day, was what the witness had told me. And him and Mr. Duval, Mr. Foster was cussing around and Duval tried to get him to quit. So he shot the gun toward Mr. Duval and he jumped out of the way. Mr. Pings is right. The bullet went in the coffee table, also went in the apartment next door, Mr. Lovelace's apartment, and kind of scared him to death. He was outside at the time. He come back in, his picture was broken and everything from the bullet. So that was the facts. If we tried the case, that was what the evidence I would put out.
Judge, if I may just very briefly, and I understand how the court, I can see your reaction. So Judge, I understand how the court feels about firearms. I think to put clarity in that situation, Mr. Duval currently right now is in Russell County on, and I'll quote Mr. Rain, one of the biggest methamphetamine cases here in Clinton County.
So he deserved to be shot.
I'm not saying he deserved to be shot, Judge, but I do want to state that fact for the record, and that is where he's at right now. You know, Judge, I think.
I just can't, when somebody intentionally shoots at somebody and misses, you said where the other fellow is, and I just think Mr. Foster would be better off serving out where he is and going on parole and let them make a decision about it. So I respectfully don't have anything against Mr. Foster, but I'm going to deny the motion. Thank you very much. Okay, Roder, I guess that concludes us there. So thank you very much. Now let's go back to Russell County and we'll finish that Russell County docket. Commonwealth versus Joshua Evans. 24 CR 0036, Commonwealth versus Joshua Evans. Are you Joshua Evans?
Yes, sir.
You born in 1988.
Yes, sir.
Last 4 digits, social security number 0079.
Yes, sir.
Correct? Okay, you're here on a pretrial conference. What do we have?
Also a diversion plea, Your Honor. Paperwork's up there.
Mr. Evans, in 24 CR 0036, a motion been tendered, so would you wish to enter, please? Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 24 CR 0036?
Yes, sir.
Is your judgment impaired today anyway?
No,
Is your
sir.
judgment impaired? Do you know what's going on here today?
Yes, sir.
Are you foggy or anything?
No,
Have you discussed this matter with your attorney and are you satisfied with his advice?
yes, sir.
If you need the evidence the Commonwealth has against you, you believe you're fully informed about your case.
Yes, sir.
You understand that you do not have to plead guilty in this case. You have certain rights under the Kentucky and United States Constitution. Before I
Yes.
can accept the plea, I need to know that you fully designate, that you fully understand these rights. And I'm gonna go over, designate them, and at the end of that, I'll ask you to understand them, okay?
Okay.
You have the right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury. Your right to be represented by counsel at your jury trial. Your right to confront and cross-examine all witnesses called to testify against you. Your right to be sentenced. Your right to call witnesses in your favor. Your right to appeal this matter to higher court if you lose. Your right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply the range of sentence provided by law. I don't have to accept the recommendation. In the event that I do not accept the recommendation of the Commonwealth, I will inform you of such. You have a right to withdraw your plea. Okay. Now, have you previously been diverted in the last 5 years?
No, sir.
Have you felonies in the last 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand if you complete the diversion program, the case will be dismissed pre-trial diverted, and you can have your record expunged. You understand that?
Yes, sir.
You understand if you fail to complete the diversion program, you'll be brought back in front of me, and I can revoke the pre-trial diversion and sentence you, and then you would be a convicted felon. Is that correct?
Yes, sir.
And that, okay, what is the Commonwealth's recommendation?
Your Honor, Mr. Evans will plead guilty to possession of controlled substance first degree, receive a sentence of 3 years, pretrial diverted for 5 years. And he will also plead guilty to criminal trespass second degree, receive a sentence of 12 months. These two sentences shall run concurrently for a total of 3 years, diverted for 5 years. Diversions will be supervised. He'll receive jail credit for 143 days as of today. He will have no contact with Kathleen Savage or property, agrees to be assessed by the SSC, pay all court costs at discretion of the court, and also all evidence in this case will be destroyed, and he'll obtain and maintain gainful employment.
What are the court costs in this case?
$155.
$155, you need some time to pay that.
Yes, sir.
Pay $30 a month, first payment 30 days from today. Now, you heard the Commonwealth's recommendation, that's what you agreed to, is that correct?
Yes, sir.
I plead guilty because you did commit the acts charged in the indictment as amended.
Yes, sir.
Knowing constitutional rights explain still your desire to permanently fix the punishment in the range committed by law. Let me get that up. Is it now? Check and see what the temperature is. There, so that's great. That's your signature there, sir.
Yes, sir.
Yeah, I'll accept the agreement and sign the diversion order. And he can get out today, is that right?
Report straight to the Monticello Probation and Parole.
You go straight to the Monticello Probation and Parole Officer. As soon as you're released, should be released today. Go straight over there, okay?
Okay, I got a question.
Okay.
There's a FTA on this case here where they didn't take me to court.
It's been recalled.
Josh, I got that recalled yesterday, so you and Robert are good to go.
Okay, thank you.
Kevin Hadex, 2028 here.
Yes, sir.
Hello, Kevin.
Hello.
15 CR 00101. Works, knows Kevin Hadex. What we're doing, Mr. Stoddard.
I had filed a 2028 petition, and we were waiting on a guardian ad litem to be appointed. Miss Persian was on it, and she withdrew, and now Miss Sawyer's done.
Yes, Your Honor.
And, I don't know if we need to have a hearing or not. I'm basically wanting a commitment order, at court's discretion until he's to be released. I guess he'd go to Eastern State up to a year.
I guess I'm going to defer to Ms. Sawyer. She's now the guardian ad litem for Mr. Hadex.
You represent him though, don't you?
That is correct, Judge, and I'll stand by
Okay, let's get her.
the opinion that
Miss Sawyers, what is your opinion as regarding?
Your Honor,
Have you had an opportunity to review him?
I have reviewed the report, Your
Have you
Honor.
interviewed- Have you interviewed Mr.?
I have not interviewed Mr. Hadex, and my reason for not interviewing him is I understand that he doesn't have the ability to assist in his defense per my conversation with Mr. Pennington. And my concern was that if I interviewed him, that it would be disruptive to the jail staff, so I have not spoken with him. I have reviewed the report, I've reviewed the file.
Have you read the report, Counselor?
I have.
What is your recommendation?
My recommendation is that, it appears from reviewing the report that the involuntary commitment would be appropriate under 202A.
What's the Commonwealth have to say?
That's my opinion.
What will that entail? You feel,
We will do an order that needs to be permitted for up to a
they
year.
usually beat them back though. don't
That's
they?
right. He'll probably go up there. Once they get jurisdiction over the case, they'll put it in front of their court in Richmond and he'll be released more than likely. Since there's no violent offense.
See, the report alleges that he's not criminally responsible.
Yes.
Okay.
Correct.
He's not able to help in his defense both or what?
Both.
Correct.
Okay. Kevin, I'm gonna sign this order and they'll send you up there and maybe an interview up there at the hospital, okay? Maybe get some resolution for you, okay?
Your Honor.
All right.
I didn't mean to interrupt.
All right, appreciate you.
Okay, you have a good day, man.
All righty, you too.
This case, I'll enter an order at this. So he was up on the revocation, well past the probationary period. I can't proceed with the revocation, so I'll just enter an order.
Okay.
It's probation.
Fine.
Your Honor, that concludes my business.
Thank you. Commonwealth versus Phelps.
Your Honor, due to the nature of Mr.
J. Reed-
Phelps.
J. Reed
report him out
Phelps.
Separately. Did you hear me, Your Honor?
It's last, sir. I think that's.
Okay. Laura Stenson. Commonwealth versus Laura Stenson. 23 CR 0016. Are you Laura Stenson?
Yes, sir.
We're here for a pretrial conference. This is 23 CR 0016. What do you have to say, Mr. Stockton, about Laura Stenson?
We have a felony plea. I don't know if you're ready or not. Well, I was notified yesterday when I was in court, didn't get the message for about 4:30 yesterday that she's willing to enter a plea. And we did the paperwork this morning that I didn't know since she.
She had the paperwork over there.
I don't think she's received it yet.
Why don't you send it over to the
That's
jail?
what I was gonna say, so.
They're gonna send your paperwork over there to you so you can review it. We'll come back to you a little later, okay?
Okay.
Spread your seat.
Candace Tweety,
Josh, can you
Yes,
grab-
Your Honor.
yeah, Commonwealth versus Candace Tweety, 23 CR 0058. Miss Tweety, were you born in 1997?
Yes, Your Honor.
Last 4 digits, social security number 2464. This is a pretrial diversion revocation. It says you're represented by Trey Wilkerson, but I don't see him here. Was he a DPA conflict?
It was.
Well, she didn't have an attorney. Just, look, I'm not gonna make any decision today, but DPA comes in and listen, what's this about, Mr. Scott?
Your Honor, she was on probation. She was on probation in this case and she didn't report. Then finally, Mr. Payne was able to track her down and basically, she failed to complete substance abuse, used methamphetamines and marijuana. I was going to refer to drug court if it was all right with the court. It's a 3-year sentence on possession. If she wants to accept it, otherwise I'll proceed with revocation.
Candace, are you interested in going to drug court?
Yes, I just, I need to get home.
That's anything else, that,
Well, she can say yes. It's a lovely thing. She
Well,
goes,
I guess I don't need anything
That,
else.
don't be that. She just like. Candace, do you want an opportunity to speak to your lawyer about this before the decision is made? What I'm gonna do is the Commonwealth has made that offer. I'll hold it in abeyance. And if you get a signed agreement on that, you won't have to wait till the next court. I'll go ahead and sign the referral.
That's fine.
I'll sign the referral. You sign an agreement that you'll do that if we do, and then we'll try to get you. I don't know when the next time they're gonna meet, but they'll have to meet and vote her in first.
Is Mr. Pennington gonna represent you?
Yes,
Yeah, you wouldn't have a conflict now, but
I don't think so, no.
all those cases are over with, aren't they? There's Kathy Phillips. Now that's John Brown. John Brown.
Yeah, John Brown was played.
This is not substantive that would have anything to do with any
I
conflict.
think, no, good.
This is just
I'll handle it. I'll be over to see you, Candace. We'll talk.
Okay, we'll see if we get the papers going on, okay? Okay, now we have,
Your Honor, we have.
we'll go back to Phelps, so we're waiting on Miss Stenson's, paperwork to be done. Hello, morning, Judge. Commonwealth versus Phelps, 24 CR 0027. Mr. Phelps, were you born in 1993?
Yes, sir.
Last four digits, social security number 4673.
Yes, sir.
What do we have here, Mr. Stockton?
I think Mr. Strange.
Yes, yes, sir.
He's just now got a point in this case, and we have to get him discovered. He's not had time.
What's the charge here?
It's sexual abuse, Your Honor.
Okay, have you been provided, where are you from, Mr.
Marion County, sir.
Marion County?
Yes, I spoke to Mr. Phillips already and I got the email from your office this morning, so we've got the discovery now.
Okay, we'll get the discovery and to keep, the matter on track here. We'll schedule you to be in Burkesville on July the 31st at 1 p.m. for negotiation. In the case, if you got all the discovery there, and you'll need to do a transport order to have your client brought down there to Burkesville. And his next court appearance will be the 8th of next month.
Judge, could we make that the September date? I am in Marion Circuit all day on the 8th,
On what day?
on August 8th.
You know, you can appear, I'd rather not extend your client's date another month. I mean, you don't know, you might be entering a plea, who knows? So let's just put it on the 8th and I'll allow you to appear by Zoom.
Thank you, Judge. I appreciate that.
And you be here, I just trust you that you can be here if you can. If you can't, you can do it by Zoom. But I do definitely want you to meet your client before the July 31st negotiation date, so you can get acquainted with each other. Mr. Phelps, he says that he's received your file and he's gonna review it and come up and see you before the 31st negotiation day, okay?
All right.
Okay, thank you very much.
Thank you, Judge.
Yeah.
That's all I have.
Yeah, be careful going home. Now, Laura Stenson's paperwork's being done, is that right?
I just had,
Yeah, we'll come back to her. And now let's go to the Clinton County Correctional Institution. Clinton County. The air conditioning kicked back on now.
Is it one of them?
Well, that's the one here talking, everybody else on the lines. Clinton County, Frankie Davidson. I see Clinton County's office there, but nobody appears to be in.
I just blew my mind.
Frankie Davidson, are you Frankie Davidson?
Yes, sir.
You're here on 24 CR 0038. Were you born in 1980, Mr. Davidson?
Yes, sir.
Last four digits of your social security number 2243.
Yes, sir.
You're on a pretrial conference. What do we have?
Judge, we've got some outstanding discovery. Commonwealth has agreed to pass this, the August 8th date, and we may reach a resolution on the 31st, so we can have that negotiating date.
Mr. Davidson will be ordered to be in Burkesville on the 31st day of this month at 1 p.m. for negotiation, and the next court date will be on August the 8th. Your attorney says he's got some additional information and to see if they can reach an agreement on the 31st, okay?
I'll be able to see you, Mr. Davidson.
All right, thanks, sir.
Okay, Ferdinand Gerger.
Ferdinand?
Commonwealth versus Ferdinand Gerger. This is not.
They're going to get him, Your Honor.
Okay. Glasses are leaving here. That's not the glasses. What are they here?
No.
Hello.
Commonwealth versus Ferdinand Gerger.
Yes, this is.
You born in 1968,
58.
58,
Yes.
last four digits, social security number 5474.
Yes.
We're here on two cases, 21 CR 0090 and 23 CR 0063 for probation revocation. What does the Commonwealth have to say?
Your Honor, this came before the court last month, or maybe 2 months ago. I'm trying to remember when it's last month. He had on April 15th, he admitted to use of meth on four occasions, March 15th, March 29th, April 5th, and April 12th. Mr. Payne had him assessed and he went to Lake Hills Oasis in Pulaski County and he was discharged from there for violating the rules. Then he absconded when he got out. He got picked up and we agreed to put him in this PSAP program, this new program where they're behind bars but they're getting drug treatment. Well, they wouldn't take him because he denied having a drug problem. So at this point in time, I'm asking that the court revoke his diversion.
And Your Honor, in speaking with jail staff, I just found out about the interview process and the results of that. I was under the assumption, like Mr. Stockton, that Mr. Gerger is going to be on his way to a facility behind the fence, but
I can't hear what he's saying.
I found out that you didn't, when you did your assessment, you didn't tell them you had a drug problem.
What is the availability? I mean, in other words, he's gonna go behind the fence to do drug rehab or just behind the fence. So
Well,
no choices.
And I didn't know that you got to be assessed and maybe keep you out. This is all new to us. This is the first time we tried this.
Here's the lady that,
Come up to the mic.
the lady that's over the program sent me the email. She said, I contacted Mr. Gerger this afternoon. Despite my encouragement regarding the importance of honesty in the assessment through the exploration of PSAP program, he continued to deny use of any illicit substance or alcohol. He continued to maintain his stance after every question I asked him about his positive drug screen and admissions to use while on diversion. He said there must have been he must have misunderstood what was going on when he tested positive. In light of this, I cannot approve him for PSAP at this point. So basically, he denied to them that he had a drug problem, and they're not gonna place somebody in this program that says they don't have a drug problem because they've got people that want it.
Good. I don't think I have any option here.
He was in drug court. Couldn't do that because of transportation issues. I mean, we tried everything. We tried rehab, we tried drug court, we tried PSAP.
Well, he had to admit he had a drug problem to get in the drug court.
He did. So I don't know.
Mr. Gerger, why, I'm just gonna ask you something, you're attorney here. Why is it that you told these folks that we're gonna try to get you in this program that you don't have a drug or alcohol problem? Do you have a drug or alcohol problem?
Yes, I do.
Well, I'm going to say that the court found on the record that Mr. Gerger admitted in open court that he has a drug and alcohol problem and refer him back to that program. I'm gonna give you another chance. These people ask you if you got a drug problem, what's your answer gonna be, Mr. Gerger?
That I do have a drug problem.
Oh, that's exactly correct. Now we're all on the same page, so we'll sign an order, send you back.
Thank you, Judge.
Okay. Brian Gross.
Come on.
Okay. Yeah.
Brian Gross.
Brian?
Commonwealth versus Brian Gross, 24 CR 0058, 24 CR 0041, and 24 CR 0031. Are you Brian Gross? Are you Brian Gross?
Yes, sir.
You born in 1985?
Yes, sir.
Last 4 digits, social security number 2218.
Yes, sir.
So you're here today for the purpose of arraignment on one charge. You have a right to remain silent. Council present. Grand jury, Clinton County determined indictment charging you possession of controlled substance, first degree methamphetamine, and possession of drug paraphernalia. Council, you acknowledge that your client received the indictment, await formal reading, arraignment, and plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order here, Mr. Gross. Your attorney being provided information that prepared for your defense. What's the story, Mr. Stockton, Mr. Gross?
He has an arraignment and 2 pre-trial conferences. I'd like to get him arraigned instead of negotiations.
Just arraignment.
Okay. So let's get him
Negotiation date for July 31st, 1 p.m. in Burkesville. Transportation order needs to be prepared if he's still incarcerated. Then the next court date is August the 8th at 9 a.m. Okay. Christopher Hughes.
Your Honor, I've been held on no bond. Is there any way I can get a bond?
You won't know about his bond. Your attorney will come talk. What's his charge, Mr. Stockton? What is his bond?
He's got 2 possessions on the cases for pretrial. In this case, it's a convicted felon in possession of a handgun.
No, you have to have a hearing on a handgun charge. Okay, thank you. Christopher Hughes.
Christie Hughes.
Andrew Murdoch on deck. Okay. Commonwealth versus Christopher Hughes, 24 CR 0047 for the purpose of arraignment. Are you Christopher Hughes?
Yes, sir.
Born in 1979.
Yes, sir.
Last 4 digits of social security number 3125.
Yes, sir.
Here for the purpose of arraignment. Your attorney is here. You have a right to remain silent. The grand jury of Clinton County is returning indictment charging you to operate a motor vehicle under influence, wanton endangerment in 1st degree, trafficking of controlled substance, 1st degree, possession of controlled substance, methamphetamine, possession of controlled substance, heroin, possession of controlled substance not in the original container, possession of drug paraphernalia, and being a persistent felony offender, 2 counts. You understand those charges?
Yes, sir.
Okay. Counselor acknowledges the event of your client received indictment, await formal reading, arraignment, interplea not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order require the Commonwealth to provide you with information to be prepared for your defense. Schedule a negotiation date on July 31st at 1 p.m. in Burkesville. Transportation order need to be done in the next court dates, August the 8th. 9 a.m. here in Clinton County.
Judge, very briefly, it looks like I'm showing Mr. Hughes has a $10,000 cash bond, correct?
I don't know what the question here, and it looks like he got about 72 grams of some kind of substitute.
I see the additional, now that I see that all.
Actually, pretty cheap bond. Okay, your attorney will be overseeing. Andrew Murdoch.
Judge, he's in Harlan County. No, I could bring him with me, but
What's he doing in Harlan County?
he's actually doing the SAP program there, but we were gonna enter into a plea. I don't know if Miss Bailey, has she entered her plea yet?
Most of waiting on her to come.
Oh, well,
I told her to go to Burkersville on the 25th. That's right. She's not here.
okay, well, and Judge, I know that case is also, since we're talking, is set for trial. I don't know that we need a trial if both parties are intending on entering the plea.
What?
Well, we need to be able to enter the plea or take the trial off the docket one, because we've got a 2 year to serve concurrent with these Elicia County cases. So I've got the case resolved. And then Mr. Croswell got the Beatty case resolved for next week.
Where are we next week?
Well, we're in.
Mr. Cross
Monroe
is back
County.
up. When's Mr. Cross's client coming to?
I don't know.
She's on the way from Eagles Cove, Moran.
To here today?
Yeah, I got confused because we were in Burkesville for the negotiation session, and I was just thinking about coming back to Burkesville on the
Well,
25th.
when is the
but she's
trial
on-
scheduled?
That next, the 17th, the next Wednesday. So I either gotta get ready for it or take it off the docket. I thought it was settled.
Well, yeah, well, we're gonna.
Well, I mean, I understand.
We're gonna take the plea, you know, I had these deathbed conversions on occasion, you know, that.
Hey, can you see if I can get a hold of Harlan Jail, get them on?
Well, Carson's gonna try to get Mr. Murdoch on, that's all right.
It's scheduled for next week.
Next Wednesday.
Hey, where's Carson?
It was set pretty quick, so that's one reason we worked on it and got it resolved. It's only time on sale.
Well, what about having them to come?
They're working on getting Harlan County name.
So you got the paperwork done up there?
We're done with it, Judge, yes, he's already signed.
Okay, well, let's just,
Do I need to send somebody a link?
If I've got the link, I'll send it. Can you send it? Can you send it to me?
So she's about here then.
okay, well, we'll come back to Mr. Murdoch. Then, and then what, Mr. Cross, what's your client's name?
Christie, baby.
Yeah, so, and she's on the way up here, right?
Yeah, she's in town. I just called her. So she.
Yeah,
works.
and is the paperwork finished of her?
Yes, sir.
Okay, well, let's go on and we got three more and then we'll go back to Mr. Hoover. Daniel Norris.
Daniel Norris?
Norris. Tomo versus Daniel Norris, 24 CR 0046, 0040, and 0030, and 0029. Are you Daniel Norris?
Yep.
Born in 1996. Last four digits of social security number 1043. Okay, what do we have with Mr. Norris?
Judge, this is identical to Mr. Barr's case. I think the court may have set this for a status to see where we're at. He has a referral to KCPC as well. That's yet, to my knowledge, yet to be completed.
I haven't seen anything.
Okay, if you'll send another order, we'll send it. Mr. Norris, you haven't been up there to talk to him at KCPC yet, have you? Okay, well, we'll try to get an order, get you up there, okay?
And Judge, I think we had tendered an order to expedite it, to do it outpatient, so he may get, well, I know. Yeah.
Yeah, usually once they get the order, if it's video, they get on it pretty quick. I don't know what the order was.
Did you do it electronically or how did you do it?
Yeah, the order's been, it was filed, it's already, they had it. Well, it's been,
Usually Dr. Anderson gets on pretty quick.
yeah.
Lloyd Owens. Lloyd Owens. Mr. Norris, we'll try to get you up there, get some help quick as possible. Lloyd Owens. Lloyd Owens. Commonwealth versus Lloyd Owens. 24 CR 004. Are you Lloyd Owens?
Yes.
You were born in 1959.
Yes.
Last four digits social security number 8020.
Yeah.
Okay. What do we got, Mr. Stockton?
Well, I've made two different offers, Mr. Allen. I think we've been in jail.
Neither one of them at this time are acceptable, Your Honor.
What's he charged with?
He's charged with 2 counts of one and aim and dangerous one of gun at each one of his sisters at different times on the same day.
Yes, and jury trial. Are your witnesses available, Mr. Stockton, are you available?
They're local, yeah. They live in just edge Clinton County, Wayne County.
What about next Wednesday?
Got a long deed, no, Your Honor, I'm covered up with, stuff next Wednesday. Since we got Beatty settled, I've got, and we couldn't get rid of that quickly.
Well, I mean, you already had one scheduled for next Wednesday, didn't you?
Well, I know that was one case and this is another. We're not in Judge Carter's court.
Well, you could be real quick. I can refer to that. I have enough long-term memory that I can just pop right in. I don't think you'd like it very much.
I don't think I would either, but I just felt like I felt compelled.
Well, I mean, your client's incarcerated. I was just trying
Yes,
to.
I know, and
And he's incarcerated because we had a motion to revoke his bond last minute and they didn't defend him. So, right, so he's incarcerated.
Yeah. Okay, well. What about the 26th of July? That's a couple of weeks out.
Your Honor, I have a conflict that day. I have a
Well, let you just pick.
break. Can we go over to, well, no, let's look at something reasonable.
Too late for that.
Your Honor, I see September 16th and 17th both open in my schedule. I think that affords us.
We have.
Problem there.
Trials scheduled in Rogan. Murder.
Well, I have
I could
23rd.
set that aside.
What about the 23rd and the 24th of September?
Not available that week.
Okay. What about
Let's go
September?
back up to August.
Okay, August pretty rough, but we'll look. I could do the,
That's the 20th.
no, I'm out. I could
Judge,
do,
I would just tell you from August the 12th through the 23rd, I will not be available.
Okay.
looks like I have the 28th available, Your Honor, on a Wednesday.
We got a Monroe County case set for that day. That's a Shirley case. Well,
That's correct, yeah.
I have, Thursday, the 22nd.
What about the 30th?
No, the 30th is no. Depositions in Bowling Green. On a doctorate's been impossible.
What about September 4th?
That'll work.
How about that, Mr. Stockton?
Well, I've got a medical appointment that I need to keep. My allergies, I got to do something like that. I have killed him. Since marriage.
What about the 3rd?
Third, I have conflict, Your Honor.
What kind of conflict?
I have Wayne Circuit Court and I have a meeting in Somerset that day.
Is there anything you can reschedule?
The meeting in Somerset, no.
What about the first week of October?
Well, we got in that and we didn't.
That October the 9th.
That's fine.
Fine with me.
And I think we could do it in a day, man.
Yeah, I've only got about 4 witnesses.
you got Cory up now?
Lloyd, I'll be down to see you in probably first of the week, okay? I would like.
Wesley Raines.
Yep, I would like to, I told Mr. Owens I would bring up a bond again today.
Well, there was no motion filed. I had my witnesses here last month and I was prepared for hearing, so I would ask that he file a motion so I can be prepared.
Wesley Raines.
It's mine too.
All right.
Wesley Raines. Commonwealth versus Wesley Raines. Are you Wesley Raines?
Yes, sir.
Born in 2001.
Yes, sir.
Last four digits, social security number 6433.
Yes, sir.
We're on 21 CR 0028, 22 CR 0066, 22 CR 65. Probation revocation. What does the Commonwealth have to say?
Your Honor, this is the case where Mr. Raines was, he had some turkeys. Or killed a turkey with a gun, and we filed a motion, and the Fish and Wildlife officer is supposed to be presenting the case to the grand jury today about the president of the firearm. So I would suggest a negotiation day on the 31st and August the 8th. You're right to wrap it all up.
I think that's reasonable. I do want to state on the record and make a request in regard. Spark Rehab would love to have Mr. Raines.
You what?
Spark Rehab has a bed for him. As far as the set of facts in this case, it's absolutely correct. He and another fellow went turkey hunting. Mr. Raines is 22 years old. I believe if somebody pulled in his driveway and said, we're going to drive to Mars, he'd get in the car and go with them.
Well, I have no objection to that as long as you don't have a firearm.
Well, we're going to try to get all this settled, but I know a rehab, an extended stay would do it good.
We'll just get, you want to do a negotiation day on
Yeah,
that?
plus, yes, July.
July 31st negotiation day, one of the next court dates, 8. Mr. Speaker Hoover, who do you have here? Well, Your Honor. Commonwealth versus Eric Claywell, 19 CR 0060. Mr. Claywell, we born in 1974.
Yes.
Last four digits, social security 9699. We are on pre-trial conference. We are, Your Honor. Okay, what we got going, Mr. Stockton?
I thought we had a plea worked out, and then I was notified that Mr. Hoover, Mr. Claywell, let us want to.
Mr. Claywell and I had a discussion yesterday as a follow-up during negotiation day. He informed me he did not now want to accept. What was the plea?
It was a DUI fourth. And the call, this case has lingered so long, it got misplaced everywhere. I was going to do 120 days and had a 90 days home incarceration in. And I was going to do an additional 30 days home incarceration and do the whatever else it was. But that was the petition.
And a pretrial diversion on the DUI and dismiss assault.
Can you do a pre-trial diversion on a DUI for?
I don't know if you can or not. But if you can't, you can't. No. I know that it says, when I read the statute, it says no conditional release and all that other stuff. So if that includes pre-trial diversion, we can't do it, we can't do it. The only reason I consider that is just because of the circumstances of the case. He's been here for 3 or 4 years and I had any more trouble.
It's been 5.
Well, I can't keep up there.
Obviously.
Your Honor, after talking to Mr. Claywell yesterday, I had referred him to the Division of Driver's License in Columbia to check on his license. I told him Houston, we could walk over to the circuit clerk's office and get a driving history, could no longer do that. And I think that's his concern. He's set to get his license back in September. And now this plea would extend that period of time, which I was unable to advise him on that. I just told him what I needed to do. But after a conversation yesterday and his decision not to accept the offer, I think ethically based on that conversation, I need to ask the court for leave to withdraw.
Yeah, whether Mr. Hoover represents him against new counsel, he doesn't, I don't know if Mr. Clay will realize it, or not, based on the facts of this case, I have no discretion to amend this charge. So I have to try this as a DUI case, and so whenever he's represented by counsel, we'll have to get a trial date and get the trial.
Okay, well, I'll allow you to withdraw and you appear back here on, I guess on August the eighth with new counsel, okay?
Sounds fine.
Now, it'd probably be good to, would you like in there for negotiations on the 34th?
Yes, counsel, I don't see any point, I went probably above and beyond.
Okay, well, just be here on July the eighth, on August the eighth at 9 a.m. and we'll just set your trial date.
Okay, sounds good.
You're leaving, yeah. Okay. Now, what else do we have?
We have Christie Beatty, who has arrived, Your Honor, belatedly, but
Christie Beatty.
that's tradition.
Harlan's on my.
Yes, Harlan's
And
here.
Harlan County's on the line, so we'll do, Harlan County, you'll be up right after this one. She's Christie Beatty. She's on the first page, how it goes.
Misdemeanor plea, Your Honor.
Commonwealth versus Christie Beatty, 24 CR 0019. Are you Christie Beatty?
Yes,
Were you born in 1974,
1976.
1976?
You like that, Gail?
No,
Last 4 digits, social security number 2047.
yes,
Okay, I understand you wish to enter a plea today, is that correct?
yes,
Are you currently under the influence of drugs or alcohol?
no, sir.
Is this plea freely and voluntarily given?
Do what?
Is this plea freely and voluntarily given?
Yes,
You do this voluntarily and freely.
yes,
You had plenty of time to discuss this matter with your attorney. Are you satisfied with his advice?
yes,
Is your mind impaired today in any way? You
No.
know what's going on? Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed?
yes,
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution before I can accept the plea. I know, even though that you fully understand those rights.
Yes.
Okay. You have a right not to testify against yourself. No one can make the same thing. Your right to speak trial is your right to be represented by counsel on the trial. Your right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. Your right to call witnesses in your favor. Right to go this matter to higher court if you lose, and right to part of the Commonwealth to be on a reasonable doubt that you're guilty of charges against you. You understand that, but enter a guilty plea, now you give up those rights.
yes,
I may consider the Commonwealth's recommendation, or I may apply any range of sentence provided by law in case I decide to do something more severe or harsher than you agreed to. You can draw your plea and proceed to trial. Move your left there a little bit, please. Mr. Stockton, what's the Commonwealth's?
Your Honor, she's going to plead to possession of drug paraphernalia, receive a sentence of 12 months, probated for 1 year. She lives in Tennessee, so probation is going to be unsupervised. She'll pay $100 fine and costs. All evidence in this case will be destroyed unless the co-defendant pleads.
Okay. Is that what you agreed to?
yes,
Were you making this plea because you didn't commit the acts that you're charged with?
you do what?
You are entering this plea because you did commit the act that you're charged with. Okay. You know your constitutional rights explained to you. You still desire to waive those, allow me to enter the judgment. Is that your signature on the form?
Yes, it is.
And what's the ultimate charge she entered a plea to? Just drug paraphernalia, drug paraphernalia? Okay. She won't, she need to give information to probation.
I'm gonna have her fill out a release just so I have her general information, but she will not need anything else.
Okay, I'll go ahead and sign this judgment today, but you'll need to, even though you're not supervised, you'll need to get probation parole some information, okay?
Okay.
Yeah.
And you also need to keep in contact with your attorney. I think at some juncture that'll be expungible.
Yes.
You expunged off your record at some juncture.
Okay.
Okay, thank you.
And I'm sorry for the confusion.
Okay, now, we've got one more person. The grand jury's here. We'll call the grand jury to come in. Somebody get that Coke bottle off there. This is Mountain Dew. Well,
Your Honor, did you all receive the paperwork from Miss Stenson that was faxed back over?
It's been received, Judge.
And has she gone over Ms. Stenson gone over the document yet? Did she receive?
Yes, Your Honor, she has, and she signed it and we faxed it back over.
Okay, well, we'll call her, right now then. I'll let them
Okay.
do it and then have the grand jury, okay?
It's a felony plea.
Where's she, the rest of you?
Yes, Judge.
There she, Laura Stenson, there you go. Commonwealth versus Laura Stenson. 23 CR 0016. Are you Laura Stenson?
Yes, sir.
Were you born in 1987?
Yes, sir.
Last four digits, social security number 4704.
Yes, sir.
We're here in 23 CR 0016. I understand that you wish to enter a plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that was just identified in 23 CR 0016?
Yes, sir.
We'll discuss this matter with your attorney. Are you satisfied with his advice?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
When you view the evidence the Commonwealth has against you, you believe you're fully informed about your case.
Yeah.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I accept the plea, I need to know that you understand those rights. We'll go over
I
them.
understand, sir.
Well, I gotta go over them anyway, and just to see you. You might have been watching them on TV or something, you know, they could be. Okay, you have a right not to testify against yourself. No one can make you say anything, right to speak or always your right to be represented counsel to your trial. Right to confront, cross-examine all witnesses, call testify against you, right to give evidence, right to call witnesses in your favor. Right to appeal this matter to higher court if you lose, right to the court will hire a Commonwealth to be on a reasonable doubt that you're guilty of charge against you. Understand by entering the plea today. You give up
Yes.
those. There's no DUI involved in this. Is there DUI involved? No. Now, I may consider the Commonwealth's recommendation. I may apply and range of sentence provided law. I may have to accept the recommendation of prior. Passing sentence, I'll ask the pre-sentence investigation report to be done by probation parole. In the event that I do something more stringent than the recommendation you agree to, I'll allow you to withdraw your plea and go to trial. What is the Commonwealth's recommendation?
Ms. Stenson pleaded guilty to theft by unlawful taking over $1,000 and received a sentence of 1 year to serve. Commonwealth opposes probation.
Is that what you understood?
Yes, sir.
Is it, are you pleading guilty because you could submit the act charge in your indictment as amended?
Yes.
Knowing your constitutional rights, is it still your desire to give up those rights and allow the court to fix your punishment?
Yes.
You understand that by entering this plea, future convictions of felonies will be enhanced with consistent felony offender law. You understand that?
Yes, sir.
Okay, let's see here. Is that your signature on there? Can you see it?
Yes, sir.
Okay, well, I'll accept the plea order pre-sentence investigation report to be done in a probation parole. There you go. And schedule this sentencing on the 8th.
Thank you, Judge. And
Is there anything else?
Mr. Murdoch's head's kind of, I see his top of his head.
Yeah, what's Mr. Murdoch?
Felony plea, Judge.
He's in Harlan County.
Correct.
Commonwealth versus Andrew Murdoch. Are you Andrew Murdoch? Can you hear me, Mr. Murdoch?
You'll have to mute it, Andrew.
You gotta put your microphone on there, the little red thing. Can you hear me now? I can't hear you. You have to put your microphone on. Why don't you ask for some help there? If somebody turn your microphone on.
Somebody in here.
There you got it. There you got it. Leave it alone.
Can you hear me?
Yeah, it's good now. Commonwealth of Kentucky versus Andrew Murdoch, 24 CR 0018. Are you Andrew Murdoch?
Yes, sir.
You born in 1999?
Yes, sir.
The last four digits, social security number 1746.
Yes, sir.
And we're here on 24 CR 118. For pre-trial conference. I understand you wish to enter guilty plea. Is that right?
Yes, sir.
Okay. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that was just identified in 24 CR 0018 as having been born in 1999 with the last four digits social security number 1746?
Yes, sir.
Now, you have certain rights under the Kentucky and United States Constitution. Have you had plenty of time to talk to your attorney? Are you satisfied with his advice?
Yes, sir.
You like you're fully informed about your case?
Yes, sir.
I'm gonna go over your rights in the United States and the Constitution, then I'm gonna ask you to understand them, okay? You have the right not to testify against yourself. No one can make you say anything. You have the right to speak trial to jury. Right to be represented by counsel at your jury trial. Right to confront, cross-examine all witnesses called to testify against you. Right to accept evidence, right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. And right to public file a comment to the unreasonable doubt for guilt and charge against you. Understand that by entering guilty plea today, you give up those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation that I may try to range the sentence of the law. I don't have to accept it prior to accepting the recommendation. I will wait a pre-sentence investigation report done by probation and parole. In the event that I do not accept the recommendation, deciding to give you a harsher sentence, I will allow you to withdraw your plea. Do you understand that?
Yes, sir.
It's Commonwealth's recommendation.
Your Honor, upon the plea to the amended charge of possession of controlled substance first degree, the defendant will receive a sentence of 1 year to serve. It'll run concurrently with Pulaski Circuit Court Case 23 CR 512. He'll pay court costs of discretion of the court. Evidence in this case will be destroyed and the Commonwealth opposes probation.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the amended indictment?
Yes, sir.
So your own free will.
Yes, sir.
And knowing your constitutional rights that you previously waived, are you still desirous of waiving those and allow the court to fix your punishment as permitted by law?
Excuse me?
Yeah, do you understand that? Are you willing for the court to go ahead and pass judgment on you within the limits permitted by law?
Yes, sir.
Do you understand that after entering a guilty plea, any future convictions of felony could be enhanced on the persistent felony offender law? You have a
Yes,
signature.
sir. Yes, sir.
I'm gonna. This purports to be your signature. Is that your signature there?
Yes, sir.
Okay, well, I'll accept the plea, order pre-sentence investigation report, schedule sentencing on August 6th.
Judge, if I may, I believe Mr. Murdoch's a state inmate, and I believe he'd be eligible to waive a PSI.
Is that correct?
Yes, sir.
Okay, we will waive the pre-sentence investigation report with that. If there's no objection to the Commonwealth, and go ahead and enter the judgment.
Thank you, Judge.
Okay, thank you, Harlan County, for your cooperation. I will be relieved. Is there any other criminal matter to come before the court?
No.
Okay, we'll bring the grand jury in then. All rise for the grand jury.
Thank you.
All rise for the grand jury. Okay, who's the fourth person in the grand jury? Okay, everybody take their seats, please, in the courtroom. Who's the fourth person? Madam fourth person, will you rise? Have y'all finished your work today?
Yes.
If 9 or more have agreed on those documents?
Yes.
You give them to the bailiff there and let me examine them. I have to keep looking at the calendar. I can't believe that April's half over this year already, you know? We're already sitting things, I mean, excuse me, that July is half over. I feel like it'll be April. And now we're sitting in for August already. Geez, that means y'all service is not too much longer. You have a very distinctive signature.
Me?
Yeah.
I think it changed a few times now.
Don't admit that, you know, the people in jail, okay. Ladies and gentlemen, the jury, the next time y'all are expected to be back here is on August the 8th, unless you're called back because of a riot or insurrection. And these days, you can't ever tell when there's gonna be a good insurrection. You can't even know what's going on in the world and everything. So we appreciate your service. I want to remind you that if anyone approaches you, tries to contact you or talk to you about anything, what you stand up, I'm on the grand jury. I'm sorry. If they persist, you immediately call the sheriff's department and report that someone's refusing to stay away from you. Also, that everything that you talk about in there is confidential, okay? So we'll see you on the 8th day of August. I think you'll. Okay, y'all are excused. All rise to the grand jury. Okay, is there any other matter to come before the Clinton Circuit Court this morning? If not, you shall stand in recess until 1 o'clock. Let's go off the record. Come here and show me how to turn this thing off. But you stop. Okay, let's come to order here, please. Do the child support docket. Garrett versus Goodman. Garrett versus Goodman.
Yeah. We don't know, it's 6 months. It would not do by 8/7, so about a little less than a month. Exactly. Like, the question I had, like, I need about it's not over. You may have. But I just don't want to like see over. I don't see no more. So they.
Judge, this is Mr. Goodman, and I went over the what we're asking to have collected by 8/7, and he's in agreement with that, Judge. Didn't have an agreed order prepared, but
600 before August 7th.
yes, Judge.
And what will his payments be thereafter?
It's $199 a month on current and then 25 on arrears.
Can you do that? Okay. Be on your way rejoicing. Carpenter versus York. Carpenter versus York.
We have an agreed order on that, Judge.
Van Winkle versus Van Winkle.
Judge, we have an agreed order on that case. Okay.
Carroll versus Block. How you say your last name? Blanky. Blanky, okay. Carroll versus Blanky.
Hey, Mr. Blanky, this is a good day. It's a motion on the file. And that's one. So like they're almost. So. Because we have an order to submit in this case.
How much is the payment?
Goes in his favor, so obviously he has no objection. It'll be $291 will be the two amount. The new amount, not the two amount, the new amount.
What's that based?
Material change in circumstances being the income.
Well, I mean, how did that happen?
I could put staff under oath or have.
No, I put him under oath. Raise your right hand. Swear testimony about to give us the truth, whole truth, nothing but the truth.
Yes.
You inquire, please.
State your name.
Timothy Blanchard.
Miss Blanky, Mr. Blanky, do you have two children?
I have two in Mississippi, and I have one that's mine up here, and I take care of another one with my girlfriend, that's hers.
In this case, have you been paying child support on two different children, ages 11 and 13?
Yes.
Okay, and your current obligation's been $480 per month. Did you ask this case to be reviewed?
Yes, I did.
Okay, and what was that based upon?
I was working at Lee's, and then I was let go because they were overstaffed, so now I'm unemployed.
Have you been working, looking for employment?
Yes, I had an interview yesterday at IGA in town here, so.
Okay, I saw where they're requesting, applications out there. Have you tried any other places also?
I put in for McDonald's online, Pizza Hut. I had an interview in Tennessee at the IGA right in Birdstown last week too, so.
So as of right now, you're
Yes,
still.
I'm still unemployed, looking for a job right now.
Okay, thank you.
You're welcome, Judge.
I'll sign it. Okay, Brown versus Brown. Brown versus Brown.
Judge, we have an order in this where one of the children has been emancipated, Judge, which changes the amount.
Morris versus Morris.
I think he's here, Judge. What's the? It goes in his favor.
It does.
What's that based on?
Mr. Morris.
Okay. Judge, this was a motion, based upon a change of wages to, based upon, having one child. Oh, this is a motion to decrease, order to pay $351.78 and based upon the new calculation from the child support office and the change of wages, it would go to $273.76, Judge. About an $80 change there based upon the new a month.
Yeah, what's it based upon?
Their wages, $10 an hour difference of what he was making.
Why is that?
Have to inquire of him.
You raise your right hand, swear the testimony you're about to give us the truth, the whole truth.
State your name.
My name is Morris.
Mr. Morris, are you paying child support through the Clinton County Child Support Office this time on one child?
Yes.
Okay, and were you ordered to pay $351.70 a month, that's 78 on this child?
Yes, that sounds correct.
Okay, and did you ask the child support office to look into refiguring your child support?
Yes, in February.
In February, okay, and what was that based upon?
Well, a job change and the fact that I'm paying child support on another kid in another state.
Okay, and
Who's
what,
younger.
and what was the job? Where were you employed?
I was in Nebraska. Well,
Oh, okay.
yes,
And did you end up, obviously you're here in Kentucky, did you move?
I was making substantially more money out there than I am now. So that's probably why that was said like that.
Okay. How'd you end up in Kentucky?
All my family's.
All your family's here? Okay, so where did you get a job at once you moved to Kentucky?
Burger King. Well, I started in Purdue Farms in Monterey. And then left there and started in Burger King, was working Major's Pizza as a second job. They cut me down to the 8 hours a week at Major's, so I dropped that job and took the management at Burger King for a little more money.
Obviously, are you still employed there? The same appear to be?
So,
Okay. And what is the income difference per hour than what it was set on to what you're making now at Burger King?
when I was in Nebraska, I was making close to $2,000 a week in Nebraska. Yeah. So,
what were you doing?
Emergency roadside service. Driving a service truck, working on heavy equipment, semis. I was around the clock. I was on call 24/7.
What about this reduction because of child support of a younger child in another state? That doesn't play into it, does it?
No,
Do what?
it does not.
I can't in Nebraska. And they want Kathy to call. Because their wages, which is on this paperwork, is $570 something a month. Right now it's set to 7 something because of arrears. He's able to drop it to 570 something, which is what the court ordered. But in order for him to do that, I'll have to pay out of my pocket to pay the arrears, which I'm not able to do. I don't make that kind of money. So he told me to let Kathy.
That has nothing to do with this case.
No.
You know, you got a younger child.
Yes.
And so this child takes precedent under our law here, the older child does. I remember you coming back up here and wondering why you've taken such a tremendous wage loss. What are you making an hour as manager there?
11. They gave me an
I don't understand you working for $11 an hour. There are too many things, too many places around here that would employ somebody with your level of expertise and equipment, stuff like that. I just don't think that you're making a legitimate effort to get a better job.
I've got 2 applications in 2 companies right now.
And where are they at?
Tyson and Kevlon and Bridgeman.
Yeah. Well, you ought to be able to get a job making a heck of a lot more than $11.
I've been trying to get on in Tyson for 1.5 years. I don't know why they won't hire me. I mean, I haven't.
What would you be making there?
I was told 15, 17 starting out.
Yeah. What about Stevens Manufacturing in Burksville? You know them?
No, I don't know.
They make, they're out of Tompkinsville. And they make these cement plants, these mobile cement plants over there. You ought to write that down and go over there. And then there's E&Y, which is a trucking company, and stuff over in Marybone. I mean, these people are begging for E&Y would be Matt York in Marybone, and then you got Stevens Manufacturing in Burksville. Both of those places. So if you've got any kind of background as far as on the road things or something like that, I'll lower it for 2 months to give you an opportunity, but I want you to be back here on October the 10th, or prove to the county attorney's office that you've got why you haven't gotten a better job, but then, okay.
I have a question. What can we do about the Nebraska thing?
I can't do anything about the Nebraska thing. You need to, whatever's done out there it has no impact. If you were paying $5,000 a month out there, it wouldn't have any impact on the obligation here.
Well, shouldn't by law that child support out there be lower than this one since the child?
I don't know what their law is. I do well to keep up with our law, and our law is that the first child has the first obligation. If you decide to procreate again, it's on you. Okay, thank you very much.
Thank you.
Okay, what's the next case you got back up?
Brett Beatty.
Beatty versus Beatty.
Yeah, this is, there was a child that was emancipated, turned 18, so that's an order on that.
McGall versus Barber.
Judge, this is the Commonwealth's motion to increase child support. Child support had been set at $148 a month, which is actually less than minimum wage, and this is our motion to modify. It's 2 children, and the obligation amount is $723 is what we're asking to be paid beginning on June 1st, 2024. Both children are receiving Medicaid in this case, and the father is obviously working, and based upon our guidelines that the child support office ran, asking it to be increased to $723, Judge. 148 is obviously that's below minimum wage for 2 kids.
We don't have, or I haven't been able to find a sheet, a
You
child.
want to move over this way?
Sure.
Oh, you're fine. I've not been able to find a child support chart to know where they came up with that 148 total. So obviously it's difficult for us to determine if there's a 15% change. A couple of things that I noticed with the proposed chart are that actually the parties are still operating, or their current order would be an equal timeshare arrangement. There are some issues with him not being able to receive that time, which we are going to be bringing some motions forward on that. But this chart does not account for the shared parenting time. Also, it gives her minimum wage, which it's my understanding she is on maternity leave maybe for a couple more weeks, but it's my understanding she regularly works at Tyson and would be earning more than minimum wage, so we'd want that taken into account. And I'm not trying to tell the court that he's been doing equal time, and he's not been getting that, but that is what the current order is that he's supposed to be getting, so.
Judge, on the equal time share, I did a little research on this and under KRS 403.2121, subsection 6, and of course that statute deals with the equal time sharing and things of that nature, but under subsection 6, it says this does not apply, the child or children is receiving public assistance, including K-CHIP, K-TAP, SNAP, or Medicaid. And both of these children have Medicaid, Judge.
So you're primarily trying to pick up money that's owed the state rather than her profiting for this, which she profited.
It's owed to her. It's owed to her.
Okay, and then
Well, what about Medicaid? K-CHIP or anything, do they come in ever to get recovering what they're doing?
We've not heard, no.
Okay.
And there was an order, at least from 2018. I'm not sure if the 2021 order, but she was supposed to be doing the health insurance. I'm not sure if that's not available to her anymore. There's Tyson, is it? That was. It's no longer reasonable. And I guess we would wait if you want to see proof of that would be another thing.
So the kids got K-CHIP, right?
Medicaid.
I thought that was, K-CHIP is Medicaid for children.
I think it's good in that program.
Is that right?
Yeah, but that's the basis of our motion, Judge, to have it increase, Judge, is,
What do you think you ought to pay?
Well, I've been a little bit of loss not knowing what her income is. I've tried to get some information on what her income regularly would be at Tyson. I don't know how much longer, if she's only gonna be on maternity leave do we know how much longer she's gonna be? 13 more weeks.
13 more weeks.
So like I said, I can run could I tender a chart?
Well, first you ought to object to his chart.
Yeah, well, and I do object to his chart.
Tell me how.
Well, because I think he should get some credit for shared parenting time. I think he should be getting his parenting time. They don't have any other order. We haven't been to court. There's not been anything the court's been saying where he shouldn't get his parenting time. I think he should be getting his parenting time. I think, that should be a kind
Is there something on the docket today about it?
and there's not. That's something we
I
don't have.
find quite frequently, I'm not talking about this father here, because I don't know. But quite frequently, people want equal parenting time, and then they don't exercise equal parenting time because they don't want to pay child support. Personally, I think it was a terrible move of the General Assembly to incentivize people to seek joint parenting time just to reduce their child support. I see it happen every day. If that motivated people to be better parents and have more involvement and that sort of thing, it'd be a wonderful thing. But my experience, it doesn't seem to do that.
And Your Honor, I don't feel that is the case here. I feel like this father attempted to do that for a long period of time. He was always told there was other extracurricular activities, and I think extracurricular activities are great, but I think parenting time is.
Well, what is the law of parents not exercising parenting time? Is there a place on your chart for that? Is the chart made for what the order ought to be or for what the reality is?
Your Honor, we're talking about a situation where I know what's going on.
I'm asking him.
Judge, as far as not exercising the parenting time, the shared parenting time, I think under the KRS, it doesn't matter if they're receiving public assistance, that doesn't apply under this statute. Yeah.
Subsection 5, right above that says, failure by one party to consistently comply with the parenting schedule shall be granted to the other party to seek modification from the court. The party may seek modification following a 50% change in the number of time sharing days and shall have the burden of proving a material change in circumstances. Well, I know, but even if it did apply, I really don't understand why 6 doesn't apply, because if the state's not coming in and trying to get the K-chip payment or whatever, I guess if the support came to the parent, they might not be eligible for these things and might save the state their money. You know what I'm saying? I'm trying to see some rationale, but not that there's always a rationale for legislation.
And you're right, I mean, this is a situation where he would show up, for time shared energy.
What do you say about the statute not applied under that last subsection?
On the last subject, well, and this is a new addition to the statute that we have been running into. I've yet to have a judge clearly, rule on the opinion of that. I think one issue, in my opinion, is that we don't have proof from her that health insurance is not available at a reasonable cost.
But she got, they're on Medicaid. So evidently somebody signed a sworn statement sufficient. If she's lying, they can get her for Medicaid problem. I wasn't aware of the fact that there was a difference. I thought children were always on K-chip and that Medicaid was for an adult. But I think Medicaid, K-chip is a subdivision of the Medicaid program, in my opinion. And she could be on Medicaid and they could be on K-chip, but it doesn't matter. Both of them are similar programs without healthcare services. I'll tell you what I'm going to do. I'm going to give you 10 days to brief the issue as to why this should not apply. And you'll have 5 days to return. And we'll, if I'm not convinced, the statute is the statute, whatever it is.
I understand.
I'm not that familiar. This is the first time I've had it broached, but I guess it's something we might as well expect to happen.
Yeah.
So you get 10 days to serve him. You have 5 days to respond. And then if I'm convinced that I need an argument, I'll reschedule it for the next relay. Otherwise, what date did you want this to be in the book?
July 1st.
Yeah.
7/1, okay.
Yeah, 7/1.
So you're not, you're not trying to, that was the date the statute, the new statute went into effect that day. Last year.
Yeah.
But I just recently, this summer, we had that issue come up at a mediation. We kind of just agreed to disagree. So this is the first time I've had a court.
You get an opportunity to illuminate.
Yeah, and learn more about it. So.
Okay. And then if, y'all submit that, if I have any, reason to have an oral argument on that, I'll schedule it next time. If not, I will enter the order, make it final and appealable, let you take it up. And find out what the statute is, okay?
Okay, all right.
Thank you. Okay, Cabinet versus Skipper. Cabinet versus Skipper.
In this case, Judge, nobody's here. Judge, non-custodial parents ordered to pay $300 a month on current and $50 on arrears. And we're asking that $600 be paid by August the 7th.
Okay. Cabinet versus Armstrong.
Judge, this is a child's no longer in foster care, so we have an order to dismiss this case, Judge.
Lower versus lower.
Judge, this is a motion to modify Wallace today, based upon one of the children, being emancipated, Judge, they turned 18 and no longer in school, Judge.
So it was 714. Going at 403 is
430, yeah.
Thank you. Nance versus Nance.
Judge, we have an agreed order on this one.
Cabinet versus Davis.
Judge, in this case, non-custodial parents are ordered to pay, it's an only case, 63 a month on arrears, no payment today. And we're asking that 500 be paid by August 7th. The arrearage right now is $2,212. Yeah, could you pay 63 by 500 by August the 7th? There's the issue. It's called those levels.
You're Beth Davis, is that correct? Yes. You understand what you're telling me you have to pay by then? Okay. Well, I will have to incarcerate you if you don't. You understand that? Okay. Thank you. Cabinet versus Farrell. Okay, what you got here?
Judge, in this case, Ricky Farrell's ordered to pay $312 a month on current and 62 on arrears. Balance right now is $1,906. There's been no payments today. Oh, did you make a payment? Good deal.
That was that one, and then that one, so.
Okay,
I've only been, out of jail since April 10th.
okay.
So I'm on
This
record,
is
so.
it.
Mhm.
Did you see that one? What she paid for?
Yeah.
Okay.
But she still has.
Okay, let's see.
Balance is correct.
Okay, yeah. She has made a couple of payments, but the balance is correct, $1,906. I see. How much do you think you could pay about 8 cents?
I can try. I know I'm still trying to gain full employment while I was incarcerated and I'm also on drug court. But I have applications.
So you're in drug court?
Yes. I'm
She in
there.
drug court now?
She.
Yes, I got out April 10th. And on drug court. I'm still trying to.
But once you, how much is the obligation you say she has?
$312 a month on current, 62 on arrears, and the balance is $1,906.
They going to the state?
So to the state.
Oh, to say.
All are going to the state?
Yeah.
Why don't you reduce that by half until she gets out of drug court?
Okay.
Thank you, Judge.
What's the age?
I'm just in two. I've only been out since April 10th, or April 10th.
Okay, we reduce it by half till you get out of drug
Thank
court.
you.
And give you some
I should be
incentive
able
to
to
stay
pay
in
off.
drug court. Okay,
Thank you.
okay, work hard at it.
Thank you.
Cabinet versus Jones.
Judge, we have an agreed order in that case. No, it's involved.
Cabinet versus Harbor.
Judge, this is a motion for a default judgment. In this case, the respondent was served on May 21st of 2024, and there was no response filed or answer filed, and this is our motion for default.
The parties married, attorney's already been established.
Yeah, it's against them all.
I guess there won't be a problem established.
Yeah. Hope not, anyway.
Father have the child or okay, is that it?
That's it, Judge.
Okay, thank you very much. Now ours come for the civil docket. Dyer Management Company versus CCHP LCC DBA Clinton, whatever. Okay.
Good morning.
Hello.
Hello, this is Tom
We got some
Carroll.
glare. Tom, we got some glare on you here.
Let's see if I can turn something off then.
You'll be in the pitch black.
Well, leave that door open and Judge, how's that?
That's better. Okay, whose motion here?
Judge, we are here today on some of my motions, as well as the court had directed us to file memorandums on the instructions. And there were some other motions left over from the last hearing that we had. I filed a motion to.
Okay, I can't, Tom, I cannot hear you. Can somebody give me some of those earphones, see if I can hear you? Okay, let's try it again.
Judge, you recently granted a summary or denied our motion for a summary judgment, and also denied a motion for the complaint to be dismissed for failure to join an indispensable party.
Yeah.
In that motion, in that order, and in the pleadings filed by the plaintiff in this action, the finding was made that there was no breach of the contract between Sheer Drug and Dire Drug. That being an essential element of the claim by Dire Drug, we are entitled to a summary judgment on that basis alone. And because their causes of actions are based upon a purported breach of that we caused a breach of the contract between Sheer Drug and Dire Drug. So we asked the court to reconsider the denial of the summary judgment. And also in your judgment, you had a phrase that this was a final and appealable judgment. Case law holds the denial of a summary judgment is not a final and appealable judgment. And if I appealed it, the Court of Appeals would in all likelihood just send it back down. Then we were supposed to be briefing.
Well, let's handle that one issue. Does anybody have anything to say on that?
Judge James Craig here on the Zoom on behalf of the plaintiffs. Just noting, we just celebrated 4 years and 2 months of this case being on the court's docket, and we just keep arguing about the same thing. every time we're here. This case is about the defendant.
I want you to specifically talk about the portion of the judgment that said that the contract between the two parties was not breached. Just address that.
What happened, we don't think Shear did, for the purposes of this case, the dispute between Erica and Kent Shear, in our opinion, is secondary to this case. The claims that are involved here come out of the conduct by the defendants.
I understand you're talking about a tortious interference with a business relationship. Is that right?
That's correct, Judge.
Yeah, I just want you to address this particular question he brings up about whether this is an element that must be present for that makes my order inappropriate. As far as the fact that you claim there was not a breach of contract by Kent Shear. Do you think that is essential for you to go forward? And if not, why?
Judge, I don't think that is essential. I am not required. We're not required to prove damages or first bring a breach of contract claim against Kent Shear before we seek a remedy against Huff for Huff's tortious conduct.
Okay, that's what I wanted to hear. And Mr.
It is
Carroll,
Huff. Okay.
Mr. Carroll, what he claims is he's after a tortious interference with a business relationship, which he does not blame upon Mr. Shear.
Judge, I don't know whether I've not heard this argument before that which had to be brought first, but there had to be a breach of the contract. He has admitted in his pleadings and in his previous arguments, and this court has found there was no breach of the contract between Shear and.
Well, he's claiming it doesn't matter whether there was a breach of the contract, that he's saying there can be, do you agree or disagree that there can be a tortious interference with a business relationship, even if there wasn't a breach of the contract?
I disagree. And if you look at the instructions that he tendered to the court, that's one of the elements. And we pointed that out in our memorandums, that is one of the elements that the jury must find, even in, not only in my argument, but in his tendered instructions.
What do you have to say about that, Mr.
Judge, I would say that I would request that you schedule a jury trial and let the jury decide this. Yes.
That's one of the elements that they have to, I want you to respond rather than you saying that I've been dilatory or it's been dragging along too long or whatever. I want you to tell me whether or not that's an element that you included in your instructions that they had to find in order to give you a verdict.
I did, Judge.
Okay.
I did that. And their tortious conduct prevented Kent Shear from fulfilling his obligations. Dire Drug Management Company did not get all of the patients from Kent Shear.
I understand that. I understand your theory of the case. I got my own ideas about what might have happened or what might not have happened. What I'm saying is if you have as one of your elements in the instructions that you have to allege a breach of contract, and I have found that there was no breach of contract, that's problematic for you, as far as I'm concerned. You agree? You say you could give the same instructions without the finding of that there was a breach of contract, that it can go to the jury on tortious interference with business association?
Paragraph 4 on page 6 of my instructions reads that Clinton County Pharmacy or Mr. Huff caused a breach of the contract between Dire Drug and Shear Drug. Yes, that is in your file. And that is what we're asking the court to instruct the jury on. And it did happen. We have submitted proof that these clients did not come over.
I'm trying to conform my previous order to the instructions that you wish to have submitted to the jury. Now, what order was that? Who drafted the order that was submitted to it?
The court drafted the order.
Yeah, did anybody get proposed? Okay. Yeah. Okay.
But Judge, your finding in that case was based upon his argument in response to my motion to dismiss for an indispensable party. He admitted that there was no breach of the contract. His client admitted it in their depositions, but he admitted it in his pleadings that he tendered to this court.
Judge, what happened was we bought clients. Robert Huff used HIPAA protected information.
I understand what happened. I'm trying to see how I can allow the case to go forward if it's a required element for you to prove that there was a breach of contract when your client said there wasn't a breach of contract between the two. And I haven't found it in an order. I'll need to alter or amend or vacate that order to say, to remove the part that there wasn't a breach of contract. If there is a breach of contract, if there was not a breach of contract, is it fatal to your case, Mr. Craig? If there wasn't, if you allege there wasn't a breach of contract?
It is a jury question as to whether or not these clients came over.
No, it's not a jury. I'm not asking you whether it's a jury question or whether they can. I agree but if you have to prove that there was a breach of contract and your client has admitted there wasn't a breach of contract between the two parties, and that I found in the judgment that there was no breach of contract, is that fatal to your case?
Judge, it would be, but the evidence that line from her deposition can't be admissible. It was a legal conclusion. It's talking about what Kent Shear did and didn't do is so far above. That's what the lawyers should be talking about. This was a legal conclusion. The clients did not come, thus there was a breach of the warranty that these relationships existed, because there was a violation, a blatant violation of federal law that would make any other pharmacist gasp, and every other pharmacist that we've talked about gasp when they hear about how egregious this behavior was in violation of federal law, and the way that Huff opened up his pharmacy.
Okay, well,
it was this gotcha moment.
I've got enough from you on that. You know, I have no doubt that there would be an issue on some of those sort of things, but I'm having a hard time getting around the fact. You know, when you ask a client, when you're taking a deposition and you ask, was that contract breached? It doesn't take a law degree. There's always been a problem in this case, as far as I'm concerned, as to why Mr. Shear wasn't named as a party. There's always been a problem there, you know, as far as whether everybody's at the table. I mean, he could have said, I didn't breach it. This employee did it. But you could, if you just said, yeah, the contract was breached through no fault of Mr. Shear's, it was breached. Maybe it was his fault that he didn't guard his information enough. I don't know, but it's problematic that I included that in that order. And I don't have that order in front of me, but I just suggested if somebody submitted a proposed order, my staff lawyer said, no, I thought maybe it'd gotten past me that somebody gave a proposed order, but she assures me.
The order states that for the agrees with the client, there was no budget contract that wasn't displayed as needed.
Yeah, the plaintiff, she reminds me that it says that the court agrees with the plaintiff that there was no breach of contract. So I don't see how you make a judicial admission in your pleadings and in the testimony and get around that to say that there's an element there that you have to have when you say that there was no breach of contract. I'm having a hard time with that. And up to this point, I've been fully ready to allow a jury to decide this thing. Believe me, I want a jury to decide it. I don't want to decide it myself. But it is what it is. So so you're saying, Mr. Craig, you have to have a breach of contract before you can get into a tortious interference with business relationship.
You don't have to file a claim for breach of contract. Kent Shear does not.
I didn't say, that's not the question I asked.
But it is important for me to say that, Judge.
Okay, go ahead and say what you want to.
That Dire Drug and Erica Collins are not required to first bring suit against Kent Shear and first get a judicial finding that Kent Shear did anything wrong under this.
I didn't say that. I didn't propose that you had to do that. But it appears to me that you have to allege that the contract was breached. If that's an element that you want a jury to decide, that you at least must allege as a precursor to you getting into the interference with advantageous business relationship, that there was a breach of the contract, whether it was Mr. Shear's fault or not.
What we said in our response to the motion for summary judgment when we filed it June of 2023, and I refiled it today, is that the warranty provision of the contract was not fulfilled. The warranty provision of the contract and the language of that contract, which is included in that brief, states that Shear has the relationships with these patients. They're implicit that federal law has been followed and that they are being transferred under the contract. Because
of that, do you allege that Mr. Shear violated the contract?
We're alleging
the contract, and you say he breached the contract?
We're saying that was not followed, and the reason it was not followed was because Huff tortiously interfered with it. Under the Horning case.
I understand that, but the basic question that I'm asking you, and I'm not getting anywhere with it, maybe I'm asking the wrong question. I'm not above asking the wrong question. But if you include in your instructions that the jury has to find there was a breach of the contract, but you alleged in your pleadings that there wasn't a breach of the contract, and you further, and I've included in an order that there was not, how do you bridge that gap there? Just about whether there was a contract breached or not.
What we have said in the gotcha moment that the defendants are seizing upon here is that Shear didn't engage in affirmatively bad conduct, that it was Huff. Yes, this warranty provision was violated because the patients did not come. And there is ample evidence attached to the response for motion for summary judgment that all of this happened in violation of federal law.
Okay, the issue is not whether it happened or not. That is a factual question for a jury as to whether something happened or not. But if you have in your pleadings and in the deposition say there was no breach of the contract, then that's not my fault that your client said that, or that you said that in your pleadings. It's not Mr. Carroll's fault that you said that. You could say the contract was materially breached by the fact that these other people did these bad acts. Now, is that your position, that the contract was breached because of the bad acts of the defendant here?
Yes, Judge, I am going to say that. I said it in my complaint. I said it when I filed it in this courtroom in May of 2020, that this contract was breached and these patients did not come over.
Okay, Mr. Carroll, do you have anything else?
Judge, he very clearly, to avoid a potential ruling by the court that Mr. Shear was an indispensable party, he affirmatively alleged that there was no breach of the contract. And Ms. Collins very definitely said that she got all that she had bought, and that there was no breach of the contract. I recall pinning her down on that very carefully, because I knew that was an element of the offense. And the court now has found that based on his argument. I don't see any way around it. Judge, I appear to have lost you. No, maybe not.
No, I was just reading something. I know you're not used to me reading anything, but I was just reading. I was looking at the response that was filed here. And tell the motion to dismiss. And Mr. Craig says, top of one of these pages here, there is no breach of contract claim at issue in this case.
That's right. There's no claim. I am not required to assert the claim. I am not required to bring Shear before the court and articulate the 3 elements of a breach of contract
Well, let me
claim.
go a little farther. There is no breach of contract claim at issue in this case. And Dire Drug is not contesting the validity of its contract with Shear Drug, nor is Dire Drug seeking relief from the contract.
We did not get what we were entitled to under the contract, and there is a remedy the Kentucky Supreme Court gives us for that. Tortious interference with contract. And I think you found it clearly in your decision that you issued.
Wait just a second.
Okay.
Well, I think that the proof that I've heard up to this juncture and your allegations would indicate that there was a breach of the contract. The fact that you keep on saying in your pleadings and other places that there wasn't a breach by the seller of the contract, by the both parties, it doesn't mean that it wasn't breached or interfered with. I don't know what the difference between breached and interfered with. If I have a contract between the 2 parties here, the 2 drug stores, and in your situation, this employee tortiously interferes with the contract, then there must have been a breach of the contract, whether it was caused by one of the parties or not. You've chosen not to proceed against Shear, and I understand that. But I just can't hardly get over the fact that you keep on saying it wasn't breached when in every element that you should have, you have to say it was breached. I'm a hard time getting over that.
Let me correct that now, Judge. I won't say that anymore. I submitted my complaint and I submitted my jury instructions that I was cutting Mr. Carroll is smartly seizing on a thread I tried to split in response to his motion for summary judgment he filed more than a year ago. The bad actor is Huff. We have a 10-year contract statute of limitations on Shear. The jury finds against us, fine. The next month, I'll be right back in front of you and I'll have Kent Shear next to me that time. But Erica thus far has insisted that Huff is the bad actor. Huff broke his professional obligations.
I'm trying to get, if that's your allegation and if that's your thing, I've ruled against a summary judgment so that you can present that. But when you have in one of your elements that there has to have been a breach of the contract and everything, and I submit that to the jury, and then your client is asked, well, in such and so you gave a deposition which you said there was no breach of contract. And then you've made these instructions, which you have to put in there that you have to prove there was a breach of contract. Didn't say who breached it. I mean, obviously the parties have to be one of the people that breached it. Somebody else could tortiously interfere. I personally don't think that there has to be a breach of a contract where you tortiously interfere. Someone else can tortiously interfere in someone's business where there is no contract. Isn't that true? Or is that an element that's so vital that we can't get there?
There must have been, there's not a requirement under the law that one of the parties fails to fulfill an obligation. But it is the ultimate aim of the party, it is the ultimate aim of the contract that is frustrated, that is the essence of the tort.
Well, then one of the elements could say that should be that the contract in this case was frustrated or was interfered with.
And if you will
That it was
submit that to
breached.
the jury, if you will submit that to the jury, I will happily type it up and get it to you this afternoon.
Okay, Mr. Carroll, what else? Yeah.
Well, Judge, it is an element. He submitted it as an element. And those instructions, I believe, come straight out of Palmore or Palmore's, whoever took over for Palmore. And
Cooper, I guess it might come out of
define.
Cooper. I guess Cooper took over from Palmore.
Yes, I couldn't think of his name.
What else do you have? I'm kind of finished here in this argument.
Okay. The second thing is you ask us to brief all the issues surrounding the instructions. And one of those that we discussed the last time was causation and damages. I have briefed that. I don't think he has, but I have a motion pending to limit or exclude all evidence of damages because there is no evidence, admissible evidence of damages. Or in the alternative, to limit it, I think, to $35,000.
Judge, we have a written brief that we did file in response to that motion. That may have been about 9 months ago. That brief is in the court's file. We're seeking the lost profits. We have expert testimony on it. The expert's name is Gruber. We have testimony from Dr.
Has he been deposed?
Yes.
Your Honor, if I may, he did not render any opinion whatsoever on damages. He apparently, and I have a motion to exclude his testimony, he apparently has issued an opinion that Carol Brown's remembrance of names of customers and her use of a publicly available phone book somehow breaches the HIPAA violations.
It does, and it's.
Well, wait a second. I'm gonna get down to the proof of damages. Not.
He has not testified one iota about damages. The defendant refused to produce any financial records in this action.
Okay.
I said the defendant, the plaintiff. We
What
sent out interrogatories.
What financial records did you request that weren't?
I requested, I think, income tax returns and I don't know, various sales and things, and they refused to produce them.
Mr. Craig?
Judge, he's required to file a motion to compel if he thinks he didn't get discovery. He doesn't get dispositive motions on discovery motions that he didn't file motions to compel on, or that this court did not order compelled. Financial records are not relevant to lost profits, and I would contend, because you're asking us to prove with a document something that never happened. Everybody here would agree, and I believe there's testimony from Gruber on this. It's $10 a prescription. That is the industry standard at $10 a prescription. And we purchased, the contract was, there was testimony about this. It came in about 1.2 or 1.3 million because there was an anticipation of 130,000 prescriptions being filled per year. And then extrapolated that into the future is how this business is valued. Erica Collins testified about it. We will have Kent Shear testify that that's what the basis of the sale was. Gruber got into this as well. Everybody knows, and this is not a secret here. All right. So if the prescriptions were there at Shear, but they went over to Clinton County Pharmacy and did not come to us because
what about the ones that went to Roberts Pharmacy?
We're not seeking profits for.
Did you reduce the damages by those numbers that went to Robert's Pharmacy?
Well, that's the evidentiary question for trial. We are going to submit how many prescriptions came, how many went over to Clinton County Pharmacy, and how many should have come to us. And that we have submitted those documents. Those have not been withheld.
Okay, Mr. Carroll, do you have anything else?
Well, there has to be a causal relationship, and Your Honor, you brought this up as well at the last hearing. There has to be a causal relationship between whatever our alleged wrongdoing was and the loss, and that has to be proven, and it hasn't been. It has been established that we, through Carol Brown, solicited 60 to 70 people. Not all of them would have come. The plaintiff in this case, Dr. Collins, testified that they had interviewed, I think, 12 people who said they had been solicited, and only 7 of those came. 2 of them came long after they were solicited. According to, and I'm using the word solicited based on her testimony. You can't just go into court and simply say, well, I've lost all these customers without having some expert testimony and a causal relationship established.
Judge, I would also submit that we have evidence. Mr. Carroll doesn't think it proves it beyond a reasonable doubt. The burden of proof in this case is a preponderance of the evidence, and we have admissible evidence that this happened. We just have to have a chance to put it in front of a jury.
Okay, you want to rule in Mr. Carroll on the motion to reconsider?
Yeah, I do, Your Honor.
Okay, and what else do you have pending? So I'll make sure I finish that.
I have the
exclusion of testimony of the expert witness.
I do, and a motion on damages.
And what is your motion on damages? To have a summary on damages?
Well, to exclude any testimony that is regarding damages, because there is no admissible testimony.
Well, that goes back to the exclusion of the expert testimony, doesn't it?
No, it's separate and apart from that. Is they don't have any proof of, they have to establish causation, and there is no proof of that. At most, they only have 70 people that were solicited. That's the maximum. And to let them come in and in front of a jury claim that they've lost these hundreds and hundreds of thousands of dollars. And Judge, I apologize. I'm working in the dark because I had to turn the lights off. Those were the main.
Okay, Mr. Craig, do you have anything outstanding that you want me to decide?
Judge, I'm required by my client to request again that we get a jury date from you. We would request a jury date as soon as possible.
Yeah, I will get you an opinion on these 3 motions that are outstanding to reconsider, to exclude the testimony of the expert witness, and I guess to do a summary on the case based upon the fact that there's no proof of submission of damages. Those are 3 issues, Mr. Carroll.
That's correct, Your Honor. I had one other motion, and I don't think the defendant or the plaintiff would object. I asked in our interrogatory answer or request that they produce the documentation to show how many people stayed with us or went to our drugstore and how many went to other drugstores. They provided that information, but not in a sworn or any type that would be admissible. And since discovery has ended, I wanted the court to rule that their filing that with me is sufficient for its admission.
Judge, that's an oral motion. I don't quite understand.
No, it's a written motion. It was made before the last hearing.
Then we've responded to it then, Judge. If it was made before the last hearing.
You're asking Mr. Craig to stipulate to the fact that you can rely upon that representation as far as the division of the previous patients of the pharmacy and where they went, if they know.
Yes, and they gave us the figures. They gave us the figures for our drugstore, Roberts, and other drugstores.
Well, I'll give Mr. Craig an opportunity to review that before I ask him on the record to do anything else. And he can, you know, if necessary, he can just have his client to by affidavit to confirm that those numbers are correct, to keep her from having been deposed again.
An affidavit would be fine, Judge.
Okay. Okay, well, thank you. I'll try to get you something out. And as far as time schedule and everything, Mr. Craig, it doesn't take us long to put things on a calendar. Here, we don't have a lot of buildup because I don't schedule trial dates until we're ready to go. And y'all are ready to go subject to this ruling and that affidavit. Both of you are, correct?
I would just need 6 weeks lead time. That's what I would request just to get the witnesses.
That seems reasonable. Okay. Thank
So
y'all
I can
very
start
much.
September the 1st.
Thank you very much.
Thank you.
Thank you, Your Honor.
Okay, McGall versus McGall.
Your Honor, this is our motion to suspend visitation, but Mr. McGall, Your Honor, is currently incarcerated in the Russell County Detention Center. Are you his mother?
Yes.
And so I don't feel appropriate doing anything unless we.
What's he in jail for?
Well, just a garden variety of things, of menacing and DUI and.
I'm just asking, it didn't have anything to do with this case.
The menacing, yes, right? Didn't he menace you? Did he threaten you?
I'm just asking what he's charged with.
Yeah.
I don't want her stating what he did.
And there is a DVO in place. So I don't want to do.
Do you think he needs somebody appointed to represent his interests since he's incarcerated?
I think the law requires it.
Yeah, I think it's so too. So.
Yeah.
So we'll, I guess, the guardian ad litem.
Your Honor, may I speak?
Sure.
I'm in behalf of my, Westfield, my son. I talked to his lawyer this morning.
No, you can't tell me what the lawyer said. Who is this lawyer?
Wanda White.
Why is she not here?
We didn't know we needed her till today.
So,
She told me if I need her to call her.
well, you better call her because you need her, but I'm going to appoint a guardian ad litem anyway because he's incarcerated. She needs to respond. Did you serve Miss White?
No, wasn't aware we needed to
Well,
serve.
she needs to make an entry of appearance here. She needs to file a written entry appearance in this case.
She asked me.
I can't tell you what, you can't be telling me what she asked you. I'm not being rude to you. You can't speak for someone else in the court because you're not a licensed attorney. But I will tell you this, that if she wants to come here, she needs to write a written entry of appearance and come here and appear in this. Mr. Cross said he wasn't going to try to proceed with anything today. And I am going to appoint a guardian ad litem in the case because this gentleman is incarcerated.
If Miss White's going to represent.
Well, I don't know. I can't tell whether she is or not. She's not here. And if he is represented by counsel, then that won't be necessary.
That'll be fine.
Wait just a second.
Thanks.
Yes.
Ms. Wanda asked me to talk to you and the judge and see if we could set it up. If we did full custody, but let him have visitation, like he can do phone chat over the phone.
Well,
And
okay.
visitation.
Let me talk to Wanda about it, okay? I
If we
will
can
talk.
do
to
all
her.
that, want to see if we would have it.
Don't know why she didn't come up, but yeah, I'll be happy to talk to her, okay?
Okay.
Thank you, Your Honor. You wait on me, I'll talk to you. Bruce, I'll talk to you later.
Okay, Johnson versus Johnson. Johnson versus Johnson. No, you just tell her she needs to make an entry of appearance if she's gonna participate in this case. Thank you. Johnson versus Johnson. No response. Says motion to enforce. By Lee Wittenberg, and there's no one present here. No attorney served. Steve Byer versus Gary Wallace. Okay, what do we have here?
Good afternoon, Judge. Nick
You get behind the
Wallingford.
microphone.
Good afternoon, Judge. Nick
Hello,
Wallingford.
good to see you.
On behalf of Mr. Steve Byer and Twin Oaks Investment Advisors, we had filed a motion to expand the roles of the conservator.
Okay, give
in
me
this
the
case.
reasons why.
The reasons
What is your
why, Your
motion?
Honor, was the updated status of, our motion started with kind of updated status of where Dale Hollow Charcoal is.
You need to speak up a little.
Sorry, it begins with where the updated status of Dale Hollow Charcoal is. They have received notice from Mr. Anthony Wilson that he is intending to claim a default upon the land. And that notice was received back in February of 2024. So we received that notice and we're concerned about the future viability of the company and those jobs at Dale Hollow Charcoal. We're seeking to take additional steps in order to protect the company. In addition, from our last motion to
Well,
today's.
before we get into, let's do one thing at a time. okay?
Certainly.
What's your response to that, Mr. Cross? You'll step to your right and let Mr. Cross have center stage.
Thank you, Your Honor. Your Honor, nobody in this room represents Mr. Wilson. I'd say Mr. Carroll's firm will, but we are aware that several months ago, Mr. Wilson sent a default notice to Mr. Wallace and Dale Hollow. As Mr. Wallingford's aware, the Wallaces and Wilsons do have a long-standing business relationship. And I think that's going to have to be dealt with in this forum or another forum regarding the status of that. But at this point in time, you know, Mr. Wallace acknowledges that they're in default and he's told Mr. Wilson that. That's all.
Are they in default?
Lack of timely payment.
Why payments?
Well, Your Honor, that's part of why this litigation ensued is last year there was a problem with, as we asserted, Mr. Byer removing money from an account which was earmarked for Mr. Wilson. And there's been only limited payments since that time. This is a huge obligation, way over $1 million. And I don't know exactly how far behind they are, but they're substantially behind. This was a purchase contract that
Is the company still operating?
yes. Yes,
Okay, stay there just for a second. And you're accounting for the proceeds, correct? They're accounting you for the proceeds they sell, even if you think they're selling another name or something, there are some accounting of proceeds.
Your Honor, I can see some payments that were made either at some point, either to Mr. Wallace and then to Mr. Wilson. But when I spoke with Mr. Wilson on the phone, he indicated he hadn't received any payment in over a year. And I was surprised by that comment. And then I followed up with him and I said, well, I've seen a number of payments that have been made to you more recent. And he backtracked off that statement. And at that point became a little bit more wishy-washy as to what he was owed and what is due. So, but all I know is what that letter says and what I followed up with in my letter to him as well. But it presents a lot of concerns about Dale Hollow Charcoal and its ability to pay some of these obligations.
Mr. Cross,
Yes, sir.
you agree that your client's company has not made these payments to Mr. Wilson, correct?
We acknowledge a default. I do not know exact amounts.
Okay. And have you provided complete records of everything that the company you represent has sold?
I think the firm in Lexington has access to all that. The court appointed them to act as a quasi receiver, I guess you'd say, to oversee this. Is that correct, Mr. Roth?
Your Honor, I think that that's a little bit of a misunderstanding as to what has been provided so far. And my understanding of the question is, has Dale Hollow Charcoal produced records that we requested? And the answer to that is no. We made.
Okay, here's the thing about it. Dale Hollow is operating charcoal. They're operating and they're selling product. And the proceeds therefrom are being used to pay for people that work there, for raw materials, for electricity, for gas, for water. Is there any money left? And if there is any money left, why has it met the obligation of Mr. Wilson that they owe? That's my question.
Well, Your Honor.
You wouldn't know that.
Well,
would you?
The land was purchased pursuant to an installment land contract. And my client, Steve Byer, had the understanding when he made the money to acquire that Dale Hollow Charcoal was going to acquire that land. Subsequently, Mr. Wallace acquired it directly with Mr. Wilson in what was an unsigned installment land contract that we didn't receive initially. We ultimately received a signed copy during the course of our mediation. So that's one of the reasons that the particular installment land contract is really, really messy. Is that this was a installment land contract that it should have been an obligation of Dale Hollow Charcoal. Mr. Wallace accepted these funds and then he went out and he contracted directly with Anthony Wilson. So and we were not provided, again, we weren't provided a copy of that contract signed until 2 months ago. So that's one of the issues as to why this particular aspect is so muddy. Now, there were subsequently conversations about a lease agreement, but no lease agreement was ever entered between Dale Hollow Charcoal and Mr. Wallace. But that is, again, our understanding of how some of this money trickles in Dale Hollow Charcoal.
Mr. Wallace's son and Mr. Wilson, who own the property, is that right? Who owns the property? Well, under the contract.
Under the contract. It becomes complicated because under the contract, Mr. Wallace owns the land contract.
Okay, who did he buy?
And he bought it from Anthony Wilson.
Okay, that's where we get it. So you're claiming that payment has not been made. There's supposed to be a lease from Cowboy.
Not Cowboy.
Well, whatever. Dale Hollow.
Your Honor.
With Wallace, correct?
Yes.
Okay. Keep on saying Cowboy. But from what I'm seeing, the charcoal business is kind of disintegrating, going to pellets anyway. So that's what they say over at Somerset.
Yeah. Well, and Your Honor, and just we had moved previously for a receiver, and you were cautious because you were worried about impacts a receiver would have. And you hinted around the idea of a financial receiver, and then you kind of were like, well, let's get this conservator involved. And so we got Dean Ford involved. But they have been resistant because Dean Dorton, because they haven't gotten paid. So our agreement was
always found people to be resistant when they don't get. Except Mr. Cross, he always represent out the goodness of his heart.
The wet, the halt, the lame, the infirm, the oppressed, the usually the broke. That's my clientele.
So that's one aspect of our concern as well, is that we are requesting that they take this more substantial role that you had hinted at as a financial receiver to control these funds and to make these decisions, including some of these
Okay,
payments.
let's say I order it. Okay. Then how are you going to control who Gail Hollis sells to, or whether somebody else is not selling some product and there's not any money running to it anyway? Sometimes you get into a bad deal and you try to muck your way out of it. And the only way you can muck your way out of it is the people that you're in the deal with have assets sufficient enough for you to go against them. You probably, I personally, after viewing this, don't think that business can be saved. It appears to me very unlikely that it can be saved because you're relying upon the people that you're suing who you claim have done this deal with the other contract to own the land and that sort of thing, and are selling it to somebody else. You're relying upon them to go back and recreate the original deal and let you in on the land purchase, which you were excluded from, that you said that there was some sort of unwritten agreement about.
Was it unsigned agreement? If there was ultimately there was a
Do you
written.
think that, do you think that'll get in the gap fillers or the uniform?
Well, I just want to make sure.
Your Honor, that the land sale contract is dated May 21st, 2021, long before, according to Mr. Wallace, he and Mr. Barett ever got into business together. The amount was $2.8 million to be paid at $300,000 per year. Now, there's been a lot of money paid to Mr. Wilson, and there's been a lot of money not paid to Mr. Wilson. $300,000 a year, it doesn't, pretty easy to go into default on it. Regarding Dean Norton not being paid.
Well, let me ask you something.
I want to, go ahead.
I understand about Dean getting.
They do need to be paid. We just hadn't got a bill until 11:56 today.
11,000?
No, they sent me, they emailed me a bill today. It's 11:56 a.m. for $7,500. It's the first bill I've
You
sent.
gonna pay it?
Yeah, we'll pay that. Yes.
Your Honor, I received a bill. Mr. Cross was carbon copy on that email. And it was at least 2 months ago. So I'm surprised that I haven't received that email.
I've ran it today to be sure that I got nothing.
Okay.
Sorry, I've ran it today because
So
Mr. Cross, how do you propose that this problem be resolved?
well, we proposed we go to mediation and we spent 2 days up there with Mr. Wilkerson and his clients. And well, yeah, and I've never spent so much time trying to settle the case. So I don't know. Mr. Wallace, by virtue.
How much money is your guy out of pocket?
Your Honor, last time we were at, I had suggested about 1.1 million.
And can he get his 1.1 million back and walk?
Your Honor, we don't think it's that much, but we have made collectively a very, very, very substantial offer to get him his money, although it would be required to do that over a period of time with some security.
How much did you offer?
I need to discuss that with Mr. Wilkerson, who represents the 2 boys, because it came through trade.
Okay, we'll go back there in the corner.
I feel like the lawyers are really putting you to work today.
Okay, seriously, I get paid to be money.
Gary.
Let's go off the record while we discuss that. Let's go back on the record. What do you got?
Your Honor, basically what as Mr. Wilkerson and Mr. Wallace have refreshed me, and Mr. Wallingford can dispute this, I think what we'd offered is something in the vicinity of $1 million, but we'd have to have terms with a very substantial monthly payment and a balloon. And there were some other offers made through Trey's clients about,
And if it was properly secured, your client wouldn't take $1 million to get out of here.
Your Honor, I don't believe that that was offered.
Well, I'm not asking you whether that was an offer or not. You heard what he just said.
Yeah.
If they gave you a secured offer of $1 million, your client wouldn't want to come back from wherever the heck he came from and get out of this deal.
Well, I'd have to talk to them.
I believe you ought to. I believe you ought to. I believe it would be in everybody's best interest to, because right now, it just appears from first blush that your client, maybe well-intended, entered into a deal here that he did not do due diligence on to see who owned the property and who was dealing with each other and who he was dealing with and that sort of thing. I hope you didn't draft the documents. I don't know.
nobody in this room did.
Well, I don't know who drafted the documents. I'm sure you didn't. I've just got a feeling. But, what you need to do is make them a firm offer. And how you can secure that so he can take it back to his client. Okay. If not, I might just blow this whole thing up and get somebody, but it's not, I guarantee you that it's not going to be in your ultimate interest to take operation of this, what's left of this company away from this gentleman and the other gentleman. It'll go to nothing pretty quick because you probably don't have a non-compete that you can enforce.
Your Honor, and I apologize for interrupting, but I think, since we are talking about settlement discussions, I think it is important for me to kind of understand, for you to understand what we were hearing from the other side, which was, because we offered to just buy the company, both Dale Hollow Charcoal and J3 Packaging, and the offer that we received to buy what's left of these companies was over $3 million. So, while
you could buy it for $3 million,
that's what the offer to us was.
Okay.
There's an addition, talking about a packaging company as well, though, that's correct, which, why they're in this case, I understand why.
Well, here's the thing about it. I've been at this a couple of years. If I had a client that had $1.1 million and it struck a deal that is convoluted with the real estate ownership and the last signed agreement and everything, and I could get them $1 million out, I think that, and it was secure.
Yes.
And I had to depend upon a jury in a hostile jurisdiction, doing it. And not that the jury won't do the right thing. I don't know. But this is a complicated piece of situation. And you're dealing with some people that have deep roots in the community and have a lot of contacts and that sort of thing. And there are people that are working out there that probably wouldn't want to work for your client. To tell you the truth. I mean, it's the way it is. But why don't you make them within 10 days? Within 10 days, I want you to make them the most generous offer that you can. You heard what he said he thought his client had. I'm not holding him to that, but that ought to give you some parameters on where it needs to be near to make him an offer. And if not, then I'll take a look at what I do to bust this baby up. The Solomon bid hadn't worked too well yet because it looks like everybody's wanting me to split that baby.
So Judge, can we, I'm kind of nervous.
And I want that bill paid.
That'll be paid.
Okay, bill will be paid. Okay, and then within 5 days, the bill to them will be paid.
Your Honor, there's one other issue, but I know Mr. Wallingford wants to bring it up, and I don't want to avoid it. Mr. Wallingford's concerned about a garnishment that's not been honored, and I've just discovered today that he sent it to me in March. I got copies of garnishments to Wilson and to somebody else, and there was one to me, and I thought it was a copy of something, but I don't think it's effective to serve me. I think I don't owe Mr. Wallace any money. He owes me, quite frankly. So
I was going to say sports you.
But I don't.
Mr. Cross is representing Dale Hollow Charcoal, and we have an obligation to serve Mr. Cross.
Just to put him on notice is, Nothing else, right? You hold any,
Well,
in case
under
he's
that-
holding any money for him, right?
On that 5.02, on behalf of Dale Hollow Charcoal.
Yeah.
Dale Hollow Charcoal is paying Mr. Wallace a wage.
I think that needs to go to Miss Denny, Christie, but I don't think
Well, I've got no problem reserving Mrs. Denny. As long as we are in agreement.
One problem solved then.
I'm not trying to avoid it. I just don't think I did.
I appreciate that.
Okay. Okay, the bill shall be paid within 5 days to Dean Dorton and Ford. Within 10 days, you'll make the best offer, and not only the offer, but to show them how it can be secured. And then y'all get back with it, okay?
Thank you, Judge. And should we renotice this motion for next month if we can't get these things?
Or
resolved?
before then, if we can't get it worked out, I'll have a special day for you.
Okay, thank you, Judge.
Okay, okay, thank you. Smith versus Huddleston.
Your Honor, that's our motion for a default. I think there's been proper service in this case on Mr. Huddleston. Quite frankly, I was hoping he would contact us and try to work this out.
What is this?
Well, what happened is Miss Smith's vehicle was at Mr. Huddleston's to be worked on, and it burned and did very substantial damage. And apparently Mr. Huddleston didn't have any insurance. I don't know how a commercial garageman would not, particularly one in the middle of town.
You think this is not substantial for the answer? You filed this.
I haven't seen anything.
You filed something in your review.
I, Tyler Huddleston, would like to reject this claim, and I have a meeting with lawyer on March 26th at 10:30. Do you have an amount that you're seeking the judgment?
Well, Your Honor, Ms. Fields was taking care of this. It's going to run into several $1,000s.
Well, I know, but I can't
exactly.
give you a judgment for
Well,
several
no, I want a
thousand.
hearing on that. I think we've got Tyler, come up, Tyler. We're just talking about you, Jim.
Okay, Mr. Huddleston, it's been said that I'm just gonna see you if you filed an answer, and we found this written thing that you put on the
Yeah,
back. Wait
because-
just a second, I'll take you to talk, okay?
Yes, sir.
And I said on the back that you were gonna get talk to a lawyer on March 26th or something like that.
Mhm.
Now, I don't know whether you have talked to a lawyer or haven't talked to a lawyer, but the problem is this answer that you filed is probably not sufficient. And are you gonna have an attorney?
Yes,
Who is your attorney?
I had
Now
an
you can
attorney
talk.
out of Mike or Ramsey's office in Monticello. I don't know the man's name because he put it over to another one. And I went and spoke with him on Monday, and he refunded my money because he hasn't filed my answer. And I need either an extension or to put it off so I can get legal representation.
Did you have insurance at your place?
No. And those, I'm not technically, I don't want to say I'm not, but they wasn't my employees. Cause it's all 1099. They was supposed to carry their own insurance, and I wasn't there.
Who was supposed to carry you? In other words, the people that are working on cars.
That was working on the cars there that day.
Are you saying they don't work for you?
They do not work for
Okay,
me.
what's the name of your place that you operate out of?
I had a Albany Service Center,
Yeah.
and see, it was a company until it was.
You don't need to tell me any more than that. I can just see. But I will give you 10 days to file an answer.
Okay.
Now, here's the thing about it is, the only reason I'm not giving a judgment probably today is because you showed up and you said you had an attorney and they were supposed to file an answer and they didn't. If you hadn't said that, now we'd still have to have a hearing on damages. What do you think the damages are? So if you have a ballpark figure.
Nearly $10,000 for what?
What kind of car was
It's like 2017.
2007 Wrangler, which,
it? Yeah, I can imagine if it totally,
well, there's a lot of damage, but
well, I know if you totally destroyed it, it wouldn't probably be worth that.
Your Honor,
What's the blue book on?
I have no idea. This was Miss Fields' case, and I've had to take it back. Your Honor, I want to take this long Tyler. Sure, Tyler's a hard-working fellow, and him having insurance is a major problem. That's what he has to deal with, and this is the consequences. But this is a case that Ms. Smith would like to work out. We'd like,
And I
haven't heard a thing from him.
I have offered a settlement.
How
And
much you offer?
I offered him $4,000. When I first talked to my attorney, they offered him $4,000.
What's the
And
blue book value of the
Your Honor,
car?
I'm sorry I didn't pay that.
I can't imagine a 2007 car of any kind is worth. You probably are not going to be able to get enough money to fix the car. It probably is the car totaled.
It's gonna have, it caught the whole motor on fire, so.
I could show you pictures of what. he
Well,
sent
I'm
me.
not getting it. I'm just asking, do you think the car's totaled?
No, sir. And they're asking for something that I don't agree with.
Well, let me ask you. Can you fix the car?
I could fix the car,
Okay. And how much you think it would cost you to fix the car?
$4,000.
Okay. Even though it burned in his place, would you be willing to give him an opportunity to fix your car back?
I mean, he caught it on fire, it didn't.
Well,
it didn't-
I myself-
I'm not, okay, he says that he wasn't there. It was somebody else caught on fire. It's very unfortunate that it caught on fire. I know I'd be upset if my car, I mean, I had a deputy sheriff in Lexington run over me when I was going to pay my property tax. It upset me and I didn't get anything about it, out of it. You know, I understand, you know.
Your Honor, I understand what Tyler's situation was. I guess this may have been Mr. Avery. I don't know if it was down there. But according to Pam, they just kind of fluffed it over and didn't even tell her about it.
Well, here's the thing about it is, wait,
Upset about it.
and what, you don't say anything else, okay? This is a bad deal. Your feelings are hurt, you're upset, you feel like you were wronged. I understand that, okay? You didn't have any insurance, don't say anything. I hope that this aren't just saying they're 1099 employees. You'll find out about that if one of them gets hurt down there at your place and somebody comes and files a workers' comp claim. Am I right, Mr. Cross?
Absolutely.
You know, so you can't operate, which, wait, don't say anything first. Because you might damage yourself by saying something, okay? So this is not a good deal for anybody. Now, do you have anybody that you would trust? You can't use the car now, right? Is it usable? Are you driving it?
No,
Okay,
it's sat there, you
okay, it's sat for a year. Do you have anybody that you trust enough that would inspect the car after he finishes working on it?
priors, we put on an estimate.
But here's what I'm saying, if Tyler fixed it, would you be content with prior reviewing to see what he's done and documenting what he's done? And I'm not saying you ought to or not, but that's what he's asking you.
Okay, well, let's see if you can't go back there and work out something. To see if they'll give this opportunity to this man to fix at his expense the vehicle, subject to it being inspected by someone of their approval. Because trusting a car is everything. If you got a car you can't trust, you don't have a car, right? I mean, I got one that's got these things that show that all my air and all my tires is not off. I saw it today. It worries you to death till you get back over there. Now, I'm not saying you should do that, but I don't know how much property or anything you got here. This guy, if you got a big judgment against him, I don't know whether it's collectible. I don't know what he owns, what he doesn't own. Do you know that, Mr. Cross?
Your Honor, I know Mr. Huddleston, like I said, he works.
Yeah.
We respect that. We've been hoping to hear from him.
Well, I know, but I mean, he could declare bankruptcy. couldn't he?
But I think it's collectible.
Well, okay, well, I want to give y'all an opportunity to talk about it. I'm not asking you to make a decision now. I'm just making a suggestion. I don't bring people up and pressure them or anything. I'll give you 10 days to get a lawyer and file an answer, but I would suggest that you'd be better off putting that money toward fixing it than you would be paying a lawyer, okay? Wait just a second. So, Mr. Cross, you get in contact with him in 10 days and make him a written offer about what it would take to see if he fixed it subject to their inspection. If you can't do that, you just need to lawyer up. And you know you're gonna have to pay him, somebody's gonna have to pay him something, and I'm guaranteeing if it's your place of business, it's gonna be very difficult for you to get out of paying it. I don't know how much it's gonna be. Wonder what, I don't have, do they even have blue books anymore?
Yeah, they do. What's your number?
What kind of vehicle was it?
1, 2, 5, 6.
1, 2.
Jeep
5,
Wrangler.
Jeep Wrangler.
Grill chicken.
They'll hold it.
That's a high price vehicle.
Yeah, it'll hold its value better than most things.
That's, I mean,
I
I understand, and that's why I'm not afraid. I'm not
Is
afraid.
it sitting inside or outside?
Inside and
Yeah, okay, so it hadn't been out in the elements or anything. Okay, y'all just think about it, see if you're comfortable doing that. If you're not comfortable doing that, we can proceed, let him get a lawyer and roll it out.
We'll look at some options.
Okay, thank y'all very much.
You got enough.
Thank you.
I'll be in touch.
So,
So we'll see.
now, do we have one more case? Okay, small claims court. Kentucky Farm Bureau versus John Dine.
Your Honor, that's our motion to bring in third parties.
Oh, hello, sir. You with Hank? Okay.
Your Honor, Mike Rosen, Kentucky Farm Bureau.
Your Honor, what happened on this, I've been sort of sitting on this, not filing anything. Farm Bureau's filed a subrogation suit to be for Farm Bureau to be reimbursed by Mr. Diamond. We have filed a motion to join the driver of the other vehicle because we assert this is negligence on their part. And I did hear from John Miller's firm today, and they said they would likely accept service, and they would have no objection. Of course, they're not parties at this point in time, only KFB is.
Your Honor, we have no objections.
Okay, just give me an order.
It's, make it happen.
Okay.
Thank you.
Thank
Please, that's all I have.
Okay,
Thank
thank
you, sir.
you.
Hope you enjoy the.
Does that conclude everything we got on the docket? Let's go up. Have him come on in.
Thank you, Your Honor.
Let's go off the record here. And it doesn't necessarily have to be. Yeah, that's no, when they were arguing that the person wasn't a specialist, it's not a specialist. So they aren't a special party, then we get in a situation where it doesn't have to be a breach of contract between the two. And maybe it is a breach of contract. He's already part. Yeah, but in this guy's, you know.